You are unmuted.
Hear ye. All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court, and before the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors. I do have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instruction and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. Everyone said no or shook their heads. Before we start, at the end of the trial, when I give you your instructions, I'll explain to you what a stipulation is. But essentially, a stipulation really is just something, a fact that the lawyers agree to. So what the lawyers want me to tell you, what they agree with, is that last Friday, when we were on our view at 34 Fairview, you may have seen an object in the front lawn. It looked like a rock. If you saw that, please disregard it. They want you to know that that was not there on January 28th to January 29th, 2020. With that, could we have Mr. Whitten back, please? Good morning.
So you're still under oath. Thank you.
All right, Mr. Alessi, you all set?
Thank you, Your Honor. May I approach?
Yes.
Thank you. Your Honor, if I may address the court.
Okay.
Mr. Brennan and I have agreed, as we did yesterday, to stipulate into evidence portions of Mr. Whitten's March 2025 report. So if I could have it marked.
Okay.
Thank you.
Exhibit 43. Thank you.
Thank you. May I, Your Honor?
Yes.
Thank you. Morning, Mr. Whiffen.
Good morning.
And welcome back.
Thank you.
May I approach, Your Honor?
Yes.
Thank you.
Thank you.
Mr. Whiffen, I've just handed you, which is in evidence as Exhibit 43, and this is a portion of your March 2025 report. If you could just take a moment to look at it, and when you've had a fair opportunity to do that, I'd ask you to turn to page 28.
Okay.
And just if you could, sir, just pick up your head and let me know when you're ready to proceed.
Okay, thank you. Thank you.
You ready, Mr. Whiffen?
I am.
Thank you. So what I'd like to do is to, with your honor's permission, is to publish pages 28, 29, and 30, and start with page 28. Thank you, Your Honor. Mr. Wolf? And if you could enlarge the text down below as much as you can so the jury can see it. Thank you, Mr. Wolf. So, Mr. Whiffen, this summary section of your report is a summary of the location section that you wrote in your March 2025 report, correct?
That's correct.
And it states the location data on this device contains a vast number of records while traveling between 12/19/33 and 12/24/38. These records all have a high horizontal accuracy value as well as bearing and speed information which conforms to the streets being traveled. Next paragraph. The device arrived outside 34 Fairview at 12/24/38 where it remained static for about 30 seconds. Do you see that, sir?
I do, yes.
And did I read that correctly?
You did.
Did I read that correctly?
Sorry, yes, you did.
So at the end of it says, show the device moving west from the roadside towards the house. That's what you wrote, correct?
Correct.
I would like you to, Mr. Wilk, if we could switch back to the timeline of Mr. Whiffen that we had published yesterday in Deck 79. Mr. Whiffen, if you could please, we just read that portion of your report that says at 25:30 the device bearing shifts to a westerly direction as location records also show the device moving west from the roadside towards the house. Did you put that in your timeline?
I did not.
It's kind of important information, isn't it?
I believe with the declining accuracy, the value that those records provided was more limited.
But it was important enough for you to write it in your report, but you didn't put it in the timeline, correct?
Correct.
Now if you could continue on your report, page 29, Mr. Wolk, if we could put, and we're going to be flipping back and forth between the timeline in your report.
Okay.
If we could go to page 29, enlarge it, the text, so the jury is able to read it along with us. We're going to start from the top. So the next says, from the combination of device location and bearing, it does appear that the device started to move towards the house. However, since the bearing information appears to be based on the location records rather than the direction the device is facing, it is difficult to say with any degree of certainty if the device actually moved. Did I read that correctly?
You did.
So the first part is again a statement could go to the next paragraph. This location data is immediately followed by 12 minutes of low accuracy records which offer no reliable location information. So I just want to make sure I've got the time period here. The 12 minutes is from 12:25, correct?
Yes.
And so
correct.
12:25 plus 12 is 12:37. So the range we're talking about here is from 12:25 through 12:37, correct?
Correct.
Then, if we could go to, Mr. Wolk, please, back to the timeline, slide 82. So I want to discuss with you the very entry, Health 12/31/56, where you have the entry, start of health event, 36 steps, 25 meters, and yesterday we agreed 25 meters is approximately 84 feet, correct?
Correct.
And that is what you have in the timeline. Let's understand what that means. At that time period, 12/31/56, do you recall writing in your March 2025 report that the device began moving for a period of 20 seconds?
Related to the location data, I believe?
Yes.
Yes.
Now, if we could, Mr. Wolk, go back to page 29 of the report. So what I want to do is go back to that paragraph up at the top from the combination of the device. From the combination of device location and bearing, it does appear that device started to move toward the house. However, since the bearing information appears based on the location records rather than the direction the device is facing, it is difficult to say with any degree of certainty if the device actually moved. So you're talking about difficulty saying with certainty, correct?
Correct.
But it is certainly possible that the device was at that location and was moving toward the house. That's possible, correct?
Based on location data, yes.
Now what I'd like to do, please, is to go, stay on that report, and the third paragraph says, the reason for such low accuracy location data at this time is not known, as there are many possible reasons why the accuracy was be reduced. There's a little grammar issue there, but
Correct.
In fairness to you, sir, we do that when we write long reports. But I think that your intention here is, why the accuracy is reduced at this point,
yes.
correct?
Correct.
Thank you. This could include reasons such as the device entered a building covered area, the result of weather conditions, geography, poor connectivity, or interference, to name a few. So those are the reasons you gave, which could contribute to some low accuracy, correct?
Correct.
Interesting, the very first reason you gave is that the device could be entering a building or covered area. And that phraseology could include a house, correct?
Correct.
It could include a garage attached to the house, correct?
Correct.
And it could include the house at 34 Fairview, and it could include the garage attached to the house at 34 Fairview, because both of those are buildings or covered areas, correct?
Correct.
Then you go on in the next paragraph to say it is known that the device was not being used at this time, and is this time that include that 12:37, 12-minute range, 12:25 to 12:37?
Yes, it was not being used for location purposes.
So that's another reason why, right, the accuracy could be a little bit on the lower side.
Correct.
Now, the next paragraph says, at 12:38:13, when the device begins recording higher, and that's relative to what it was recording before. It's not that it's high, but it's higher than what it was just moments before.
Correct.
The data centers on a location slightly closer to the house than the roadside. Although several records show the same center coordinate with differing accuracy radii. Some of these location records are shown in the map below in white. So let's go down and look at what you had in your report for the area in white. In the area in white that you're referring to, there are two white circles, the largest there. This, in fact, was a depiction that you included in your report on page 29, correct?
Correct.
Interesting and notable, you did not include that depiction in it, did you?
I did not know.
In your report, correct?
Correct.
And notably, the larger white circle covers a substantial amount of the house at 34 Fairview, correct?
Correct.
So, given your testimony on direct yesterday with Attorney Brennan, the phone of John O'Keefe, according to this depiction, could be anywhere within the largest white circle, correct?
Correct.
And this depiction was not offered by you or the Commonwealth in your presentation to the jury yesterday, correct?
Correct. Not in the PowerPoint.
Now, if we could go back, Mr. Wolk, to page 29 of your report into text. And enlarge the text just a little, please, for the jury, Ms. Wolk. So the paragraph that begins with at 12:38:13, when the device begins recording higher accuracy information again, the data centers on a location slightly closer to the house than the roadside, although several records show the same center coordinate with differing accuracy radii. Some of these location records are shown on the map in white below. And I repeated that just to tether, to connect this part of the text to that diagram with the big white circle. Have I done that correctly?
Yes, correct.
Thank you, sir. The next paragraph. Over the next few years, the GPS coordinate and associated accuracy radius jumps around. Yesterday, you discussed Waze, the Waze application with Ms. Attorney Brennan, correct?
Correct.
And you stated that Waze location data is more accurate than the data that comes from the data. In your view, accurate location data.
There isn't really a thing such as Waze location data.
I'm having trouble hearing.
Waze location data doesn't really exist. Waze is requesting location data from location services, and location services would respond with high accuracy information.
Okay, I appreciate that correction. So,
Correct.
if we could, Mr. Wolk, go to page 30. what I'd like to highlight, please, is the text. So if we can enlarge it up at the top. So you then state, while location data from this data source, cache SQLite, is usually able to identify the location of the device with a high degree of accuracy and reliability, these records are so close that making a distinction between the device's actual location on the front garden is impossible, correct?
Correct.
Your words, impossible.
Correct.
Did you provide any of the information in that paragraph in your timeline or to the jury in your direct testimony yesterday?
Not in the PowerPoint, no.
Next paragraph. If the location records are limited to just the records between 0025, which is 12:25, and 6 a.m. and with an accuracy radius of 10 meters or less, there are 46 records, all of which fall within the red circle shown below. Go ahead, Mr. Wolk, if you could scroll down. And that is the only depiction there that you included in your timeline yesterday, correct?
Correct.
So you took one of two depictions in your summary of the location, this one in terms of your timeline presentation, correct?
Correct.
Now, in terms of the timeline, and Mr. Wolk, if we could go back to the previous with the other depiction. It's on page 29. If we could enlarge that depiction, please. So, you testified that the flagpole in the fire hydrant are more down toward the small black circle. Is that correct?
That's my understanding, yes.
And yesterday, you rendered an opinion that you believed that the phone was mostly in the location by the flagpole in the fire hydrant, correct?
Objection.
Members of council at sidebar for a minute, please.
May I, Your Honor?
Yes.
Thank you. If we could dim the lights again, please. Thank you. So, if we can enlarge that depiction. So, yesterday, Mr. Whiffen, you focused your testimony and your opinions on the smaller black circle, correct?
Correct.
And you didn't discuss at all or disclose at all this depiction, and therefore didn't discuss or disclose at all the larger white circle, correct?
Not when discussing my overall opinion.
Right.
Yeah.
So the answer
Is no.
right. So the fair way to interpret, and this is what you put in your report, this is your depiction, is that, and based upon what you said yesterday, the phone could be at the very edge of the top of the circle, correct?
Correct.
And the phone could also be at any point, so you can, in theory, put a phone anywhere around the very edges of that entire circle, correct?
There's caveats to that, but yes.
Well, I'm just asking
Yes.
you that according to your testimony yesterday in this depiction, the phone could be anywhere in that location
Yes.
within the area of that white circle.
Correct.
I would like to now go back to the timeline, Mr. Wolf, where we had left off, which is slide 82. And at the very top entry, you have health, time 31:56, and then the description, start of health event, 36 steps, 25 meters, and we agreed about 84 feet. And this is where the device began moving toward the house for a period of 20 seconds.
Of travel.
On behalf of a report that states that there was a trigger event at 12:31:56 that they refer to as the supposed collision. Are you aware of that?
Objection.
Sustained.
I recall seeing a
So you
report.
don't have-
Sorry.
Yep, you don't have to answer that.
Sorry,
Mr.
apologies.
Wilson, that's okay.
Mr. Whiffen, are you familiar with a firm called Aperture?
I'm vaguely aware of them. I've heard of them once.
Are you familiar with a person by the name of Dr. Judson Welcher?
I'm not, no.
But you're familiar with the firm Aperture?
I am.
And do you know that the Aperture firm is working on this case?
That's the only reason I'm aware of this company.
Right. And do you know that the Aperture firm has used your data in your report? Do you know that?
I believe I saw something about that.
You believe you saw something, or do you know that they've used your data for a report in this matter?
I recall seeing a report. I don't recall whether it was my data that was being referenced.
Do you recall seeing a report from Aperture?
I do.
So you reviewed a report from Aperture.
Several months ago, yes.
And did you read the whole report?
It was a PowerPoint presentation, I believe.
Yes.
Yes, I reviewed it.
And you recall reading that entire PowerPoint presentation?
I don't recall what it said, but I remember reading through it.
Fair enough. Do you remember, as you sit here today, reading about a trigger of a number 1162-2? Do you recall reading that?
I recall seeing reference to a trigger event.
What did you understand the Aperture they meant by trigger 1162-2?
Objection.
Sustained.
Do you recall the specific slide that discussed a trigger?
Objection.
Do you recall that, Mr. Whiffen?
Very vaguely.
Would it help your recollection if I showed you a slide from that report that you said you reviewed to refresh your recollection?
I object.
All right, so why don't I see counsel at sidebar? Bring that with you, Mr. Alessi, please.
Tucker.
May I, Your Honor?
You can approach.
Thank you. Mr. Whiffen, I'm handing you this, excuse me, Mr. Brennan. I'm handing you this document.
Thank you.
May I stand by the witness? Sure. Tell me when you've had a fair opportunity to take a look at that.
Okay.
Thank you. Mr. Whiffen, does that refresh your recollection with regard to an aperture report that discusses a trigger of 1162.2?
It does, thank you.
Pardon me?
It does, thank you.
And how does it refresh your recollection?
I remember seeing that several months ago.
I'm sorry, Your Honor. There's a blower on here that I'm having trouble hearing Mr. Whiffen. If you, sir, could bring the mic, it's not your fault. If you could bring it and speak a little louder, I'd appreciate it.
Yeah, I recall seeing that as part of the report that I read 2 months ago.
And you recall the time of 12:31:38 now, correct?
Correct.
Let's go back to your timeline. '82. So you just spoke about a trigger 1162.2 associated with a time of 12:31:38, and we are now at the timeline of 12:31:56, correct?
Objection.
Sustained.
We are now going back to the timeline, deck 82, and you see up at the top where it says health 31:56. You see that, sir?
I do.
And then it says start of health event, 36 steps, 25 meters, which we have said is 84 feet or so. And this is when the device begins moving, correct?
Correct.
And that is after the trigger of 1162.2, correct?
Objection.
Sustained.
Let's go to the next entry on the timeline, which is 12:32:03. You see that? That's Doppler.
I do.
And then you state pocket state cleared. Is the phone at that time in a pocket?
It's impossible for me to say. I can say that the camera was blocked, but I don't know what was blocking it.
You're saying at this point the camera is blocked?
It had been blocked, and at that point, it became unblocked.
So at this point, it became unblocked from a previous block status, correct?
Yes.
Does there have to be some human manipulation of the phone at 12:32:03 for that to happen?
Technically not. There are scenarios that wouldn't require it.
Is it more likely than not that there had to have been some human contact in action for this pocket state clearing event to occur?
Yes.
12:32:04 is the next. It's a type unlock. Device unlock with Face ID. You see that, sir?
I do.
Is there some human action that has to occur for the device to unlock with Face ID?
Typically, you must be paying attention to the phone.
Sorry, sir?
You must be paying attention to the phone, assuming that that setting's enabled.
So someone had to be looking at the phone.
Yes.
At 12:32:05, application focus. What does that mean?
That the messages application was at the foreground of the device being used.
Next entry, 12:32:06. We discussed this it says read message, pull behind me, and that is associated with a Jen McCabe, it's the Jen McCabe message of 3147, correct?
Correct.
And does a human have to be reading that for that entry to be made?
The message needs to be on screen. If the conversation with Jen McCabe was already on screen when the device was unlocked, then that message would automatically be considered read.
Next entry, app lock 123209, end application focuses messages, and then it says device locked with lock button for the last time. That requires human interaction with the phone, correct?
Correct.
And it actually requires somebody to take the cell phone and press the side button to do that, correct?
It does, yes.
So there has to be some degree of coordination for that to occur, for a human to be able to have something that hits that button, correct?
Certainly, yes.
Do you understand what the term fine motor skill means? Do you
Yes.
understand that? And would that person have to be using fine motor skills to do that?
Yes.
Next entry, 123216. End of health event, 36 steps, 25 meters, again 84 feet.
That is in your timeline because that's when you believe the end of the health event, the end of the 36 steps occurred, correct?
That is the time that the device data shows the end of the health event, yes.
May I have a moment, Your Honor?
Yes.
Thank you.
Do you need the light, Mr. Alessi?
Yeah, it would be helpful. Thank you,
Could we
Your
have the
Honor.
lights, please, Dave?
Do you recall writing in your March 2025 report the following? The final health activity of note on John's phone can be seen to have occurred between 12/31/56 and 12/32/16, during which 36 steps were recorded, covering a distance of 25.4 meters, again, that 84 feet, according to healthdbsecure.db. Do you recall writing that?
I do.
And you used in your report 36 steps were recorded covering a distance of 25.4 meters or 84 feet, correct?
Correct.
Do you know a trooper named Nicholas Garino?
I'm aware of him, yes.
Are you a little more than aware of him? You've worked with him on this case, haven't you?
He sent me some of the files related to it, but further than that, I've got no relationship with him.
But isn't someone sending you files on a case you're working on, working with the person? Isn't that a fair conclusion?
It could be.
Do you recall reading any reports of Nicholas Garino?
I don't recall reading a report by Nick.
Does that mean you didn't read it, or you just don't recall reading it?
I honestly can't remember if I did or not. I remember some of the reports that I read for this case. I don't recall if one was by Nick.
Would it refresh your recollection if I showed you a portion of his report to determine whether you would have read it?
Please.
Thank you. Moment, Your Honor, please.
Sure.
Thank you, Your Honor.
May I have a moment to get this? Thank you.
May I approach, Your Honor?
Yes.
Thank you.
Show Mr. Brennan.
Yes. I just want to make sure I got the entire report. Mr. Whitman?
Thank you.
May I stand by the witness, Your Honor? Thank you.
I am providing you with a document, and I would ask if that refreshes your recollection as to whether you've read a report of Mr. Garino.
A report or this report?
This report. Thank you, Your Honor.
I don't recall ever seeing this report.
Have you ever had any conversations with Trooper Nicholas Garino?
Very briefly.
But you have, the answer is yes.
Yes.
Did Trooper Garino tell you that he measured the distance from the flagpole to the front door and it was 72 feet? Did he ever tell you that? Object to the floor.
Sustained.
Did you ever have a conversation with Trooper Nick Garino about the distance from...
Maybe.
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 So is it maybe then you had a conversation with him in which he stated to you that that distance is 72 feet?
It's maybe.
So if we go back to what we were discussing earlier about the steps and the distance covered, and this is in your report of March 2025, where we've talked about this, and it's the final health activity of note on John's phone can be seen to have occurred between 12:31:56 and 12:32:16.
Is this the correct slide?
No, it's not.
So let's take it down.
Thank you, Your Honor. Let me start that over. The final health activity of note on John's phone could be seen to have occurred between 12:31:56 and 12:32:16, during which 36 steps were recorded, covering a distance of 5.4 meters, or 84 feet. 84 feet is greater than 72 feet, correct?
Correct.
So if the distance from the flagpole to the front of the house is 72 feet, and your report notes steps, 36 steps covering a distance of 84 feet, that would put those steps within the house, correct?
It would.
Let's continue on with the timeline. Deck 83. We now have Doppler 1233:14, and then Doppler pocket state. Do you recall in your report adding a word to this, that your report said pocket state detected? Do you recall writing that?
More than likely, yes.
Yes. But the detected word is not on that slide, is it?
It's not, no.
What does pocket state detected mean?
That there was an active check by the Doppler function, and it detected that it was in a pocket state.
May I have a moment, Your Honor?
Yes.
To switch? Thank you. Thank you, Your Honor.
Do you need this slide up there, Mr. Alessi?
I was just going to check that. I think the answer is going to be no, Your Honor. I would now like to change gears a bit and go to temperature with an iPhone. You recall that discussion in your direct testimony?
I do.
Thank you. Mr. Wilk, if we could please have the slide deck, but a different page, slide 60. And just tee it up, but please don't put it on the screen yet. iPhones don't record ambient or the environmental temperature where the phone may be at any given time, correct?
Correct.
But the iPhones, including the iPhone of John O'Keefe, log the temperature of the battery inside of it, correct?
Correct.
And as a result of that function, examiners and folks like you can use the battery temperature of an iPhone to identify increases or decreases in temperature within the environment that the iPhone is physically located in. True?
I believe so, yes.
And that's right out of your report, right? Your March 2025 report makes that very statement, correct?
Yes.
The battery temperature of an iPhone generally matches the pattern of the rise and the fall of the thermometer temperature, correct?
From my testing, yes.
And when an iPhone is in a lock state with little activity occurring on the device, the battery temperature is heavily affected by the ambient temperature in the environment, again, matching the pattern of the rise and the fall of the thermometer temperature, right?
Correct.
And what I just read is right out of your March 2025 report, correct?
It sounds like it is, yes.
And you actually established this in various temperature testing and test scenarios in your March 2025 report, correct?
Correct.
Let's discuss those two tests. You had an appendix to your report that discussed two test scenarios with regard to temperature, correct?
Correct.
Can
And
I
that
just
was
ask,
appended-
I'm sorry, Mr. Whiffen, do you have your report with you, sir?
I don't have a copy in front of me.
I'd be happy to provide him with a copy of his report so we can have him follow along.
I think that's great, thank you.
Okay, sure.
Would that be helpful, Mr. Whiffen?
Very, thank you.
Yes.
May I, Your Honor?
Yes.
Thank you.
There you go. Mr. Whiffen, feel free at any time to reference that report.
Thank you.
And if you could, turn to page 77.
Okay.
So, are you ready, sir?
I am, yes.
Thank you. So let's look at test scenario 1. Test scenario 1, you took an iPhone, if I'm remembering correctly, same model as John O'Keefe's?
I believe John O'Keefe's was iPhone 11. I used an iPhone 10.
But sufficiently
similar.
similar for purposes of this experiment?
Correct.
Or this test?
Same iOS version.
Yes. So it's the same iOS version, the software inside the phone, just a different model.
Yes,
And it's a software that's important for this test, correct?
I believe so.
So you state that you placed the iPhone inside a freezer, correct?
Correct.
And now if we could, Mr. Woke, if we can put that, do we have that would be page 77? And if we could enlarge that chart, please. Enlarge it just a little bit more. We're not concerned with the text at this point, so we can just get the chart as large as possible. Thank you. Thank you. So what I'd like to do is focus on January 29th. Excuse me. This is your experiment. When did you do test scenario 1, approximately, the date?
This is a good question. It was sometime probably in December last year.
I'm sorry.
In December last year, I believe.
December 2024.
Correct.
So what you did here was you took the phone, you put it inside a freezer. What was the temperature of the freezer?
I actually don't know.
But it was a freezer.
It was freezing. Yes.
It is sort of your just regular freezer that
Yeah,
everybody
a
has.
regular chest
Nothing
freezer.
special about
No.
it. Let's look at some of the data that you have from this. Let's start at the 1710 time frame where it's placed in the freezer and you've got, and we're going to go with Fahrenheit, if that's okay with you.
Of course, yes.
Thank you. 73.4 degrees, correct?
Correct.
And then if you go all the way down to the 1725, which would be 15 minutes, correct?
Correct.
Can you state what the drop in temperature is of the battery temperature in just 15 minutes in a freezer?
Approximately 50 degrees Fahrenheit.
So it drops 50 degrees Fahrenheit in just 15 minutes.
Correct.
And is it fair to say that if you do the math, that that's about a little over 3.5 degrees per minute? And if Your Honor, if he wants to use a calculator, or just accept my estimate, whatever Your Honor thinks is appropriate.
However you can answer the question, Mr.
I'm
Whiffen.
happy to accept your answer. That's fine.
Let me just make sure. I have a moment, Your Honor. 3.33, would that sound fair, sir?
That sounds fair.
So it's about 3.3 degrees Fahrenheit per minute drop, correct?
Correct.
Now let's go to the next page of your report, page 78, where test scenario 2. And in test scenario 2, you took the same phone with the same software and you placed it outside at a temperature of 33.8 degrees Fahrenheit, correct?
Correct.
And we could enlarge that, please, Mr. Wolf? And if you could just scroll up, well, just if you just leave it there is fine. So if we take the time that we start out with a control temperature, and then we've got a battery temperature at 9:02, and this is the battery temperature of the iPhone, correct?
Correct.
And we've got 66.2 degrees Fahrenheit, correct?
Correct.
So is it fair to call that a baseline for purposes of what this chart is?
The device had already been outside for 2 minutes at that point, but yes.
Okay, so we'll just refer to 66.2. And then if we go from 9:02 down to 9:15, a period of 13 minutes, correct?
Correct.
So at 33.8 degrees and 13 minutes, what is the drop in temperature in degrees? What's the drop?
Sorry, between the 9:02 and the 9:15?
Right. So does it go from 66.2 to 35 point? That drop at 30.6. Does that sound about right?
That sounds correct. Yes.
So you got a drop of 30.6 degrees in just 13 minutes at an outside temperature of 33.8. Correct?
Correct.
We're going to come back to this, but what I'd like to do is to compare these two test scenarios. The one we just saw at 33 degrees Fahrenheit, where it dropped 30.6 degrees in just 13 minutes, again at an outdoor temperature of 33.8, and then test scenario 1 in a freezer, where it dropped 61.2 degrees in just 15 minutes. Now let's go to the slide 60, which was in your slide presentation yesterday, of what you stated was the temperature change in the iPhone of John O'Keefe on the morning of January 29th. You with me, sir?
Yep.
Thank you. So if we start out at 12:13, we see a battery temperature of 82 degrees Fahrenheit, correct?
Correct.
Then it drops a little bit to 77, a little bit to 72. And what I want to focus on is keeping the starting point for my questions here at the 12:37 time period on the morning of January 29th. And that's 72 degrees Fahrenheit, correct?
Correct.
So if you take the time period from 12:37 to 12:53, that's a 15-minute interval, correct?
Correct.
The phone only drops 11 degrees Fahrenheit in 15 minutes, correct?
Correct.
If you then go to 12:37 and give it a little bit more time, down to 1:36 a.m., the temperature, and that's just about an hour, right?
Correct.
And the temperature drops from 72 to 50, only 22 degree drop in an hour, correct?
Correct.
Now, if you compare this chart in the drop in temperature, for example, 1237, 1253, in 15 minutes, it's only dropping 11 degrees, to your experiments, where with the first scenario with the freezer, it dropped $50 degrees in a 15-minute period. Is it correct to say that there was a much more dramatic drop in temperature in your test scenario 1 than what actually occurred on John O'Keefe's phone for the time period we just covered in January 29th?
Yes.
And then with regard to even test scenario 2, where the temperature is 33.8 degrees, that's the ambient, the outdoor temperature,
Correct.
right? At that temperature, just above freezing, you've got a
Sorry, that's below freezing.
I'm sorry?
It's below freezing.
What is freezing in Fahrenheit?
Don't know, but it's 0 degrees Celsius,
Right.
and it was -5 degrees Celsius at the time.
Right, but would you agree that, and I want to be fair to you because I know you use Celsius more
Yes.
than Americans who use Fahrenheit, but would you agree that 32 degrees Fahrenheit is the freezing point in Fahrenheit?
I honestly wouldn't know.
Okay, fair enough. So, in any event, in your experiment at 33.8 degrees Fahrenheit, you're getting a drop in your experiment in 13 minutes of 30.6 degrees, right?
Correct.
But much less drop in temperature on slide deck 60 of the actual iPhone of John O'Keefe on the morning of January 29th, correct?
Yes, correct.
Do you know what the temperature was in Canton in January 29th, 2022?
I do not know.
Don't you think that that would be an important piece of information in analyzing where the phone of John O'Keefe was on the morning of January 29th?
I didn't think it was.
So you didn't think it was important, even though you issued a report discussing the temperature of the iPhone, and you did 2 test scenarios, one in a freezer, one in an ambient temperature of slightly above 33 degrees, and you didn't think it important to take the final step to see whether there was anything to be gained from that comparison to determine where that phone was located?
My testing proved that the battery temperature is affected by ambient temperature. My report shows the data that was on the device. I also don't know the condition that the phone was found in, whether it was in a case, whether it was in a pocket. So to me, the ambient temperature in Canton at the time wasn't particularly relevant. I just wanted to show what data the device had recorded.
The information that you create from your digital forensics analysis, including everything that's in the slide in your report, including battery... You all set, sir? I'll go back to the question. In digital forensics, you work with law enforcement often, correct?
Correct.
And you work in law enforcement in investigating cases
do you not?
Yes.
And so oftentimes, the law enforcement is using your digital forensics information to help them solve cases, correct?
Correct.
You didn't suggest to anybody on law enforcement that they might want to take a look at this temperature information to assist in determining where this phone could have been by the temperature? You never raised that with them?
I did not.
And do you know whether any law enforcement person was aware that you had done all this temperature analysis?
It was in my report.
So you create a report as part of this case, and you deem the temperature important enough to do 2 test scenarios, important enough to put it in a slide presentation to this jury. Yet there's no discussion of that between you and any member of law enforcement as to what it means?
The details were provided in my report, and there was discussions, but it never came up as to say what was the temperature in Canton that night.
Oh, so there were discussions.
Not with law enforcement.
Oh, who
As
were the
part of my preparations for trial.
Oh, tell me about who you discussed this temperature information with.
It was with Hank.
You're hesitating, and I can't hear you. Who did you discuss
with
it
Hank.
Excuse me?
With Mr. Brennan.
Attorney
Sorry,
Brennan?
Yes.
You discussed temperature with Prosecutor Brennan.
It was in my report.
It was in your report, but you said you discussed. Which is it?
It's in my report, and the discussion was that it is in my report. I'm not in a position to suggest that investigations take place and change based on my report findings.
Oh, sir, I'm not suggesting what you just stated. I'm just trying to get information about, you mentioned the verb discussed. Didn't you, in your
Yes, I
answer
did.
moments ago?
Yes.
Isn't discussed a verbal thing? It's not a written thing?
It was discussed in preparation for trial, yes.
Oh, so there was a discussion, a verbal discussion with Attorney Brennan about temperature in your preparation for trial.
Yes.
Was there any interest at all as to what this could actually mean for the potential location of Mr. O'Keefe's phone on these very important time periods in January 29th that might assist to determine at various times whether Mr. O'Keefe is in a covered building based upon the temperature rather than outside in a nor'easter on January 29th?
I'm sorry, what was the question there?
Yeah, the question is, was there any discussion about the investigative value of what you had done in determining where that phone could have been on key time periods on the morning of January 29th?
That wasn't part of the discussion, no.
It was a report where you stated that it was possible that the phone could be inside the house of 34 Fairview based upon that big white circle. You testified that the low accuracy at certain points could be because of it entering a covered building, correct?
Correct?
And you do a temperature experiment to track the very accurate temperature change of an iPhone, and it doesn't match up the actual data with either of your test scenarios, and you don't raise that with anybody. Objection.
Sustained. You can ask it differently.
Did you ever put together in any kind of form your test scenario 1, your test scenario 2, and the actual temperature chart of the iPhone of Mr. O'Keefe?
Sorry, how do you mean put it together? As in compare the two?
Exactly. Compare the two and reach any conclusions about location, because you spent time, did you not, sir? A lot of time in your reports on location of the phone.
Yes.
But yet, with all that data, all that testing, all the experiments that you didn't include in your slide presentation, and you didn't include in your report what that could mean for the location of the phone, did you, sir?
I'm struggling to see the comparison there.
Let me see if I can ask it in a different
Please.
way. Nowhere in your slide presentation did you have any discussion yesterday about how your test scenario, did you bring up, by the way, in your slide presentation yesterday, your battery temperature at all, your tests?
Not the tests, no.
Right, so you didn't even raise yesterday in your presentation about where the phone might be located. You didn't even raise the experiments that you did, correct?
Sustained as to the terminology. Ask it differently.
Did you yesterday, in your presentation to the jury, in any way discuss your battery test scenario 1 and 2 in your March 2025 report?
I believe there was mention of testing, but not to the amount of detail to say what the testing was.
Right. So there was no detail given at all
No
about
detail.
it. You just mentioned that it occurred, but no detail in your discussion
Correct.
at all. And are you aware, with regard to the battery temperature, that battery temperature in investigations can be used to determine locations of phones at certain times? Are you aware of that?
No.
So you have never used battery temperature information in all your years in any way for any investigation of a case in determining location of a phone?
Again, I don't see how you can determine location of a device from a temperature reading, other than to say whether it was inside or outside.
So battery temperature and the chart that you gave that is up there, in your opinion, has no relevancy to the topic of where a phone might be to investigators in a case? Is that what you're saying?
Is that what you're saying, Mr. Whiffen?
I'm saying I can't take a temperature reading and make a determination about a GPS location based on the temperature reading.
That's not my question, though,
Okay.
sir, and I appreciate your answer, though. My question is, you work with law enforcement investigators regularly,
Yes.
correct? Isn't this information of potential relevance based upon your experience with investigations? Isn't this information at least potentially relevant in investigations?
I believe it could be. That's why I included it in my report.
Thank you. But you didn't include a discussion of it in your testimony yesterday, correct?
Correct.
I just want to be clear on a final point as regards temperature. Were you aware of the temperature in Canton on January 29th, 2022?
I know it was a blizzard, but I don't know what the temperature was.
May I have a moment to switch
Sure.
topics? Thank you, Your Honor. Thank you, Mr. Whiffen. I'll be right back. Your Honor, if I may, I have one last point to make with temperature. If we could put deck 60 back up, please. Mr. Whiffen, if you bear with me, I just have
course.
one final set of questions. If you look at this chart, and you, under January 29th at 12:13, battery temperature of 82 degrees, but you then go down, what I'd like to start with is 12:37 again, and this is a key time point, 12:37. You've got a temperature of 72 degrees, and then 8 minutes later, 8 minutes, the temperature only drops 6 degrees, correct?
Correct.
Again, using 1237 as what I refer to as the baseline, you go all the way down, and you see to 1253 a temperature drop of only 11 degrees. Do you see that?
I do.
Thank you. That you can, excuse me, Your Honor, one moment.
Okay.
The final data point on this slide, Mr. Whiffen, and thank you for bearing with me on this. At 136, there's a temperature of 50 degrees Fahrenheit, correct?
Correct.
Several hours later, at 6:06, 4.5 hours, the temperature drop is only 7 degrees, correct?
Correct.
I'm switching. May I have a brief moment, Your Honor?
Okay.
Thank you. May I approach, Your Honor?
Yes.
May I have exhibit 42, please?
What is Exhibit 42?
It's
Okay, thank you. We've got it. Thank you, Tori.
May I hand it to the witness? Your Honor?
Yes.
Mr.
Thank
Whiffen,
you.
I'm handing you exhibit 42.
Yes.
Do you recognize Exhibit 42 from your March 2025 report?
I do.
And sir, just take a fair time to familiarize yourself with the exhibit before I start asking you questions. They're going to be very brief. And I'm going to be, you look what you need to, but I'm going to be focusing on just under detailed analysis communications on paragraph 3, on page 43, the top 3 or 4 entries.
Okay.
Tell me when you're ready, sir.
Okay.
Thank you. Your Honor, may I have 43, which is in evidence, so if we can just go to detailed analysis, communication, call history, and now if you could just super enlarge the first few entries. Yes, that is great. So what I want to do is just cover the information here. Whose phone is the subject of the entries on this chart?
This is John's phone.
And if we start with the first entry, reading left to right, 12:14:36, end time 12:15:20, incoming call from Jen McCabe, duration 44 seconds. You see that, sir?
I do.
You see, and is that a call that is answered?
Yes.
If you go to the next entry, 1847, just 12:18:47 to 12:19:23, outgoing call, duration 36 seconds, to Jen McCabe, duration 36 seconds. Do you see that, sir?
I do.
Is that a call that is answered?
Difficult to say. That could be a outgoing call that lasted 36 seconds of ringing, but I believe it was answered.
Well, how is it that you can tell the first one was answered but not the second one?
Because it's an incoming call.
Okay, fair enough. So if we go to the third entry, 12:29:44, 12:29:51, incoming call from Jen McCabe. You see that, sir?
I don't mean to interrupt. Could I ask about the display?
Mr. Sadler. I'm told this seems like an appropriate time to take our morning recess, so why don't we take a 15 or 20-minute recess?
Please rise for the jury. The jurors right this way. Please leave your notebooks closed on your chairs, please.
So do you guys think that somebody really framed her and beat him up? Go lay down.
Court is in session, please be seated.
Whenever you're ready, Mr. Alessi.
Thank you, Your Honor. May I approach, please?
Yes.
I have a replacement.
Okay.
So, Your Honor, I have a replacement Exhibit 42 redacted, obviously to replace Exhibit 42, and it's per stipulation with Mr. Brennan.
Yes, please. Vigil's going to be ID, C. Thank you.
May I present it to Mr. Whiffen, Your Honor?
Yes.
Thank you.
You're welcome, Mr. Whiffen.
May I publish, Your Honor?
Yes.
In Mr. May I, Your Honor?
Yes.
Mr. Whiffen, we had started going through the top three entries. The first one you had indicated was answered. The second one you, as I understand it, could not tell. Is that correct?
Correct.
And then the third entry, which is reading left to right, 12:29:44, end time 12:29:51. Incoming call duration 8 seconds from Jen McCabe.
Correct.
That's the third one. So because it's an
So,
incoming...
Mr. Alessi, we need to enlarge this.
Okay, Your Honor. Mr. Wolf, can you enlarge that pursuant to the judge's order? Is that sufficient, Your Honor?
If you can make it as large as possible for the jurors, please, even if you have to do smaller segments.
If we have to, Mr. Wolf, knock off the final right-hand column, that's insignificant. There you go.
All right, that's better. Okay, that's fine, thank you.
May I, Your Honor?
Yes.
Thank you. So I want to now go to the last one for this Exhibit 42. It's reading from left to right, 12:29:44, 12:29:51, incoming call duration at seconds from Jen McCabe. Again, it restates duration 8 seconds.
Correct.
Given that it's an incoming call, you can conclude that that was answered, correct?
Correct.
Now, if we could go back down and focusing on just the first three by way of example, Mr. Wolf, do just as Her Honor has requested, enlarge it as large as possible. Those three, after the first three, yep, starting there, just take the first three by way of example. All right. Mr. Whiffen, you should feel free to look at the hard copy Exhibit 42 if that's more helpful to you. But what I want to do is to focus on start time 12:33:35, reading across activity, incoming call, unanswered, and then to the right, Karen Reed. Do you see that, sir?
I do.
And do you see the same types of entries for 3409 and 3438?
I do.
And those calls are unanswered, correct?
Correct.
So in contrast to the, and now Mr. Walker, we can go back to the chart, trying to capture 6 and enlarge those once last time. Thank you. So in the first one at 1436, and then skipping one to 2944, those are answered, but then starting, excuse me, at 3335 and 3409, those are unanswered, correct?
Correct.
You can take that down, Mr. Wolf. Thank you. We have a moment, Your Honor, to switch topics. Mr. Whiffen, when did you start working on this case? What was the date, approximate date?
On this case or on this exhibit?
On this case?
Approximately September 2023.
So, over a year and a half?
Correct.
How many times have you been in Norfolk County?
This is my second time.
So you were here once previously?
Correct.
Do you recall yesterday discussing what you had done with an iPhone, driving around and then moving it with your hand?
Correct. Yes.
In the year and a half that you've been on this case, did you ever take an iPhone and do the same activity on the route that you were discussing yesterday between 34 Fairview and One Meadows?
I actually did it on Sunday night.
I'm sorry?
I did it 2 days ago on Sunday night.
And with regard to your time on this case, what was the results of that?
I object, Your Honor. I'll need to be heard briefly.
I'm sorry?
I object, I need to be heard briefly.
Okay. Come on over.
May I, Your Honor?
Yes.
Mr. Whiffen, I am now going to proceed to a different topic.
Okay.
Do you recall discussing the Google search, how long to die in the cold?
I do.
And you discussed that in your direct testimony, correct?
I did.
You were a police officer for years before getting into the data forensic analysis of cell phones, correct?
Correct.
You were a response officer of the South Yorkshire Police from 2004 to 2009.
Correct.
You continued policing with the Calgary Police, working patrol, correct?
Correct.
You work frequently with law enforcement.
I do.
Indeed, law enforcement is the predominance of your work, correct?
Probably about 80% of the work, yes.
What percent?
About 80%.
80?
80.
Your work is used in investigations for law enforcement, correct?
Sometimes, yes.
In your area of work, you use and apply various forensic methods that are extracted, that data is extracted from a cell phone, correct?
Correct.
And you have various forensic methods to analyze that data, correct?
Correct.
And that data that you analyze is often used by law enforcement in their investigations, right?
It can be, yes.
It can be, but it also is, from your experience, correct?
I'm sorry, are we talking about my actual analysis or analysis that's created by the tools that me and Cellbrite create?
Your analysis.
Okay, my analysis is typically used in investigations, yes.
So it's typically, your analysis is typically used by law enforcement.
On the cases I work, yes.
Right. And you know that is going to be the case oftentimes when you're doing your analysis, correct?
Correct.
And forensic software is used to gain access to people's devices, correct?
Correct.
Such as cell phones, right?
Correct.
So, and there's something called an extraction process from a cell phone that you discussed in your direct testimony.
Yes.
Now, I'm not going to go into too much detail, but I want to cover, because it would be covering old ground, but I want to cover some of it.
Okay.
It's important, is it not, that the extraction process that's extracted from a cell phone is complete, correct?
Correct.
So that the data is correct,
Correct.
and so that the data is reliable.
Correct.
And data forensic examiners and people in your area of work need to ensure that the extraction file has not been tampered with, correct?
Correct.
Because if an extraction file has the possibility of tampering, then the information and data from it can be unreliable, correct?
Correct.
And there's a generally accepted methodology for how to perform an extraction of data from a cell phone, correct?
Typically, yes.
One of the key ways to determine whether the data extracted from a cell phone is valid and has integrity is to evaluate whether the extraction process created what is called a hash value, correct?
Correct.
And a synonym for a hash value is a hash signature, correct?
Correct.
And a hash value or hash signature, I'm just going to use hash value. Is that acceptable to you?
I'm fine with that.
Thank you. So a hash value is a unique and usually consists of a long string of numbers and letters that's generated from the data file from a cell phone using a computer algorithm, right?
Correct.
And one of the computer algorithms is SHA, SHA 256, right?
Correct.
And is it a fair analogy to state that a hash value can be thought of as fingerprint for a data file from a cell phone?
Yes.
And is it also a rough analogy that a hash value can function like the seal on a milk container? In other words, if you open the milk container and the seal's broken, that the same analogy can be provided that if you don't have a valid hash value, then there is a question with regard to the contents of a cell phone, just as there might be concern about contents of a milk carton. Is that a fair general analogy?
Yeah, if the hash doesn't match, then something has changed in the data.
So if the hash doesn't match or you can't determine a valid hash file, It's sort of like opening up a milk container and that seal cap is off, correct?
Okay, I'll accept that.
Thank you. Now, if a data file is altered in any way, the hash algorithm is going to produce a different letter in numeric string than the previous hash value for that same alleged data, correct?
Correct.
So that alpha numeric number is important because it can, if it's different, then it means something happened to that data, correct?
Correct.
And isn't it important for examiners, anybody in data forensics, to know whether or not the data they're looking at has a valid hash value?
It would depend, in my opinion, on the origin of the data.
But you would agree that it's much better to have a valid hash value for data than not, correct?
I'd like to see the hash value match, yes.
You would like to see the hash value matching,
Yes.
correct? Now, once data from an iPhone is properly extracted and you get a hash value, then the examiners of the data seek to pass and decode the data to try and make some sense of the data in a more user-friendly format so that a report can be created for investigators, correct?
Correct.
Do you recall preparing a report for the iPhone belonging to Jen McCabe dated December 2024?
I do, yes.
And in that report, you discussed your views of a Google search of how long to die in the cold, correct?
Correct.
And in that report, you rendered various conclusions about that Google search, correct?
Correct.
And you rendered various conclusions about what is called a timestamp.
Correct.
And the timestamp that was in question was 2:27:40 a.m. on January 29th on Jen McCabe's phone, correct?
Correct.
And the question that you were looking at is that timestamp that appeared in the data, that timestamp of 2:27:40 a.m., whether that belonged to the Google search, how long to die in the cold, correct?
Correct.
And you testified yesterday with regard to that very issue, correct?
Correct.
Now, in your report of December 2024, you discussed the hash value of that cell phone, correct?
I believe so, yes.
Yesterday, in your direct testimony, you didn't mention anything about the hash value with regard to Jen McCabe's phone, did you?
Not in my testimony, no.
The answer is no, correct?
No.
However, isn't it correct that in your report of December 2024, you had an issue with the hash value from the data from that phone?
I didn't have an issue with the hash value at all, no.
So you didn't note that it was not possible with the gray key extraction as the PDF containing the extraction hash value, that it was unsigned? That was not an issue in your report?
The hash value matches, but because I didn't do the extraction, I'm unable to actually validate that was an original hash and hadn't been modified.
Exactly. So you didn't do the extraction, but you couldn't validate the hash value, could you?
No.
So you couldn't determine whether or not any of the data on that cell phone of Jen McCabe had been tampered with, correct?
I take a holistic view of the data and try to find anomalies and didn't see any that raised any flags.
That wasn't my question, sir.
Okay.
I'll try it a different way. You concluded that the hash value was unsigned, correct?
Correct. They were always unsigned. Okay, apologies.
You concluded that the hash value was unsigned, correct?
Correct.
Thank you. And you went on, did you not, in your report to say that this hash value could be used as a suggestion of authentication, but cannot be guaranteed 100%, correct?
Correct.
Did you discuss any of that doubt, that suggestion of authentication but can't be guaranteed 100% at all in your direct testimony yesterday?
I didn't know.
And again, hash values are very important concepts for data forensic examiners, correct?
For integrity, yes.
Do you know the chain of custody of Jen McCabe's iPhone?
I don't know.
So you don't know the chain of custody of her iPhone. You have an unsigned hash value, and you can't guarantee the hash value authentication, correct?
No.
The objection's overruled.
Not from the hash value, no.
Go back to the 22740 timestamp and the question of whether that timestamp is associated with a Google search, house long to die in the cold. You understand there is a dispute as to whether that search was performed at 2:27:40 a.m. as the timestamp states, or whether that was performed later in the morning, say around 6:23 a.m., correct?
Correct.
You understand there's a dispute?
Yes.
And do you understand that the defense asserts that that timestamp means what it says, the Google search occurred at 2:27:40 a.m.?
We're going to allow it. Do you understand that?
I do.
I didn't hear your answer, sir.
I understand.
You understand that?
Yes.
So there are various data forensic tools, are there not, to evaluate what include Celebrite tools, your company's tools?
Yes.
And some of those Celebrite tools are called Physical Analyzer.
Correct.
And then you have another tool, I believe, called Insights.
Insights is a suite that includes Physical Analyzer, but yes.
So it's Insights is a
It's
suite.
essentially the same tool.
Essentially the same tool, so does Insight, well, essentially, but they're two different tools, correct?
The two different versions of the same tool.
Thank you. Two different versions of the same tool.
Yes.
But there are other tools from other companies, are there not, sir?
There are.
And a competitor of Celebrite that can be used to analyze that 2:27:40 a.m. timestamp and to potentially resolve that dispute of whether the Google search "How Long to Die in the Cold" occurred at 2:27:40 a.m. or later at 6:23 or so a.m. There's other companies and tools that can be used for that, correct?
Correct.
And isn't one of the companies that can be used a competitor of Celebrite called Magnet Forensics?
Correct.
And they have a tool called Axiom, AXIOM, that evaluates questions such as this, correct?
They do.
And is Magnet Forensics a reputable company?
They are.
Am I correct that yesterday you essentially said that as of today, no Celebrite tool, no Insight suite such as Physical Analyzer, today shows that 2:27:40 a.m. timestamp?
Correct. If you use any version from the last approximately year, that timestamp won't show up.
It won't show up as you sit here today.
Correct.
But that's not always been the case
Correct.
with regard to Celebrite forensic tools, correct?
Correct.
As a matter of fact, in the first proceeding in this case, in June of 2024, when you testified under oath, the situation with the forensic tools was Celebrite Forensics Insights did not show the 2:27:40 a.m. timestamp, but another version of Physical Analyzer did show it, correct?
Correct.
In that second program, that second tool, Physical Analyzer, not only showed it at 2:27:40 a.m., but it showed it as a deleted state, correct?
It's a deleted record, yes.
A deleted record.
Yes.
Did you mention that yesterday in your direct testimony?
I don't believe so.
You don't believe so?
No, we changed it since then.
Exactly, you changed it since then.
Yes.
Your company removed it
Yes.
after the first trial.
Before the first trial.
Well, you removed it from one tool before the first trial, but you didn't remove it from the other Physical Analyzer program, did you?
Up until the following version was released.
No, I'm talking about the time of trial when you were testifying.
I appreciate that. There's some complexities with how we released the software, which resulted in one being released several weeks later and one being released several weeks earlier.
At the time of trial,
Yes.
last year in June, when you were testifying under oath, one of the Celebrite tools showed the timestamp of 2:27:40 a.m., correct?
Correct.
But that timestamp doesn't exist anymore, and it doesn't exist today, does it?
Correct.
Celebrate removed it.
Yes.
You mentioned...
Could I see counsel at sidebar for just a minute, please? Go ahead,
So-
Mr. Larson.
Thank you, Your Honor. So with regard to the first proceeding, there was one Celebrite forensic tool that still showed the 2:27:40 a.m. timestamp,
Correct.
and it was shown in a deleted state.
The record was deleted, yes.
The record was deleted. And then after that, Celebrite outright removed the timestamp from, so none of its programs had it, correct?
Again, if I could explain a little bit about how it works.
No, I'm sorry.
Okay.
If you could just respond to my question. Is that correct?
The timestamp's been removed, yes.
However, the competitor of Celebrite that we just talked about, Magnet Forensics Axiom,
Yes.
that program at the first proceeding showed the 2:27:40 a.m. timestamp, correct?
Correct.
And as a matter of fact, as you sit here today, the Magnet Forensics program, Axiom, still shows the 2:27:04 a.m. timestamp, correct?
As far as I know, yes.
And Magnet Forensics Axiom is a reputable company, correct?
Correct.
Celebrite removed that 2:27:40 a.m. timestamp, which was in a deleted state, in response to issues raised in the first proceeding, correct?
It was changed because of the research that I did, and that was verified by the forensic research group.
But the issue arose because of what had come up in the first proceeding, correct?
In the first investigation prior to the proceeding, yes.
In the first investigation in this case, correct?
Yes.
So Celebrite, after the first proceeding, after the investigation, just outright went and removed the timestamp.
It's not unusual to change the
I
coding.
didn't ask if it, I just asked whether
Yep,
they
we
were.
removed it.
But Magnet Forensic Axiom still shows that 2:27:40 a.m. timestamp, right?
Again, they refer to it differently, which is why they can
But
do
they
that.
still show it.
They do still show it.
Can you just finish the answer?
So-
Sorry. Just let him finish the answer. Is that what you said, Mr. Brennan?
Yeah, my apologies, but I'm having trouble hearing, but I'll pause more just to make sure you're done. In that 2:27:40 a.m. timestamp, the dispute is whether it's associated with the search, How Long to Die in the Cold, correct?
Correct.
Let's talk a little bit more about the first proceeding in this case. In terms of your testimony under oath in that first proceeding, do you recall stating that it was your opinion as to whether that 2:27:40 a.m. timestamp was associated or not with the Google search, How Long to Die in the Cold?
I believe so.
Right, so you called it your opinion.
Yes, probably.
You didn't describe it as a fact, you described it as your opinion, correct?
Correct.
Because you realize that there are other fair interpretations of that timestamp and when the Google search occurred, correct?
I think even if I believe it's a fact, it's my opinion.
Right, so it's your opinion.
Yes.
So you also, do you recall stating that there's plenty of other evidence on that extraction that shows what activity was occurring at 2:27:40? You recall that?
Correct.
And you used the word evidence, correct?
Correct.
But that evidence on the Celebrate program is now gone, correct?
No,
It's not gone?
it's not gone.
So the 2:27:40 timestamp still exists in Celebrate programs?
Sorry, are we talking about the additional evidence that shows what
Oh, no.
happened at 2:27:40?
No, I'm just asking whether.
Okay.
I thought we had that clear, but I thought, is the 2:27:40 a.m. timestamp show up on any Celebrate program as you sit here today?
The decoded value does not show a timestamp for
Thank you.
that artifact.
Sir, does your work include shaping? So you shape how the data is going to be, correct?
Yes, we have
Yes?
ways to create the data so it's usable, yes.
So the answer is
shape it.
yes,
Yes.
you shape the data.
Yes.
These various forensic tools, Celebrate, Insight Suite, including Physical Analyzer, Magnetophoretic Forensics Axiom, these are all tools, and we know that no one has access to the Apple source code on iPhones, correct?
Correct.
And the best source of information about what may be happening inside of an Apple iPhone would be if one could get the source code and look into the source codes to see what's actually happening, correct?
Correct.
So what happens is, in data forensics, because Apple considers it proprietary and people can't access the source code, there's these various data forensic tools that in some ways try to serve as a surrogate, given the fact that there's no access to source code, correct?
Correct. That's fair.
So the best information would come from the Apple source code, but nobody has access to that, or few people do. Therefore, these other forensic tools are used.
Correct.
So sometimes examiners have to give opinions, like you give, because you don't have access to the source code, correct?
Correct.
So it's your opinion, oftentimes, with regard to ultimate conclusion.
Based on research and testing. But yes,
Not
it's an opinion.
100% absolute certainty, because you don't have access to the source code, correct?
Correct.
You have a moment, Your Honor, to switch topics, please?
Yes.
Thank you. Before I do switch topics, a couple points on the 2:27:40 timestamp, if I may, Mr. Whiffen. The Google search in question associated with that timestamp, the dispute over that, is house long to die in the cold, correct?
Correct.
And you understand, sir, do you understand the significance if Jen McCabe made that Google search, house long to die in the cold, at 2:27:40 a.m. instead of 6:23 a.m.? Do you understand the significance of that?
Of course.
Sustained.
He said yes, Your Honor.
I'm sorry? I said sustained.
Oh, thank you, Your Honor. I didn't hear that.
Jurors, strike any answer that may have come.
What do you understand to be the significance of the dispute over 2:27:40 timestamp?
Sustained.
Mr. Whiffen, with regard to the 2:27:40 a.m. timestamp, have you looked at any forensic tools to answer that question other than Celebrite tools and your tool Ardex?
I've used Axiom as well.
So you used Axiom, and so did you therefore see that 2:27:40 a.m. timestamp still appeared?
Yes.
Did you discuss that with the jury yesterday, that you analyzed the Axiom program and that 2:27:40 a.m. timestamp still appears?
I didn't, no.
You did not?
I did not.
Could we please, with the court's permission, put the PowerPoint presentation back up and go to deck 26? Mr. Whiffen, does an iPhone discriminate between whether it's in a car, a bus, a bicycle, or walking?
It can, but I don't have the research on that.
Right. So as you sit here today, you can't say that an iPhone can tell the difference between a car, bus, bicycle, or walking, correct?
The iPhone can, but I haven't researched that data fully enough to understand it forensically.
So as you
I
sit here,
can't, but
you
the phone
can't.
can.
Does an iPhone merely register movement? Let me rephrase that. Does an iPhone register movement?
It does.
Do you recall yesterday discussing movement at a speed of about 1.4 miles per hour at 12:24:37 a.m. on
Yes.
January 29th, 2022?
I do.
A person walking at a normal to even a slow pace can walk at approximately 1.4 miles per hour. Is that correct?
It sounds reasonable.
And does it sound reasonable that a normal speed of walking is between 2 and 4 miles per hour?
Reasonable.
Switching topics, Your Honor, if I could have a moment. You can take that. Okay, thank you. When you were examining Jennifer McCabe's phone, you used an operating system called iOS 14, correct?
That's one of the versions of iOS I used, yes.
That was one of the versions.
Yes.
Do you understand that Jen McCabe's phone was actually using iOS version 15?
Yes, I do. 15.2.1.
15.2?
2.1.
Thank you. And do you recall saying, with regard to iOS 15.1, etc., that the iOS operating system, your words, had fundamentally changed, correct?
Correct.
Now, with regard to, we're back to Jen McCabe's phone, we're back to 2740, the issue of deletions. You stated yesterday that that deletion occurred after January 31 of 2022, is that correct?
Correct.
But you couldn't determine how that deletion occurred with certainty, correct?
Correct.
And you gave 3 possibilities that you analyzed, correct?
3 or 4, yes.
3 or 4. And one of them was deleted by user, correct?
Correct.
Another one was that the search occurred but never loaded.
That would be the reason that there was no data found in the history.db file.
But that was another of the 3 or 4 reasons, correct?
That wouldn't cause the deletion of the record
Right, but-
necessarily.
Right. And then you you discussed those possibilities, but you can't state with certainty how that deletion occurred, can you?
Correct.
You have doubts about how it occurred, is that fair?
Yeah, I have an idea how it occurred, but I can't prove it.
I'm sorry. I didn't,
Yeah, no, it's okay.
No, please finish. I want to make sure you finish.
I have an idea of how it occurred, but I've not been able to replicate it, so my idea is unsubstantiated.
So is it fair to say you have some doubts
Yes.
about how the deletion occurs?
That's fair.
And you believe Your Honor, that is the extent of my questions of the witness at this time.
Okay. Mr. Brennan?
Thank you. Good afternoon.
Good afternoon.
As a forensic analyst, do you study data?
I do.
Do you consider it a science?
I do.
Are you a criminal investigator like a police officer in your present role?
Not anymore.
Are you a detective in your present role helping aid one side or another in an investigation?
I'm not, no.
At some point, you and I spoke about reviewing phones.
We did.
You had begun your whole process in some of this work before you had met me.
Correct.
And I'd asked you to look at Mr. O'Keefe's phone.
Correct?
Did I ever tell you what you should look for?
No.
Did I ever tell you what I wanted to see or what I wanted the results to be?
No.
Did I ever share with you parts of the investigation that had nothing to do with your actual data analysis?
No.
Would it be inappropriate or not helpful for an advocate to provide you information that might taint or influence your thinking when you're looking at data in a case?
Objection, Your Honor.
100% it would be problematic.
When I asked you to look at data in this case, did I ever express any opinion whatsoever that I cared, one way or another, what your results would find?
No.
Did I ever attempt to shape or influence your process by offering you information that had nothing to do with your assessment of data?
No.
And so as a scientist, what a legal investigator or an advocate for either side thinks, is that relevant to you?
No.
The data is the data?
The data is the data. I can explain my opinions on the data.
The science is the science?
The science is the science.
That's sustained. Watch the form.
Now, counsel showed you some parts of your report regarding John O'Keefe's cell phone, didn't he?
Yes,
You saw select pages from that report,
correct.
a few pages you were asked about,
Yes,
but you wrote an entire report, didn't you?
I did.
And do you think that your entire report puts into perspective some of those select pages that you were shown?
Definitely, yes.
I move to introduce Mr. Whiffin's entire report.
May we approach your Honor?
Okay. Do you still have your report with you, Mr. Whiffen?
I do, yes.
Okay.
Let's start with questions that counsel asked you about the battery. When you were trying to determine how the battery worked, you shared with the jury that you did certain testing.
Correct.
What was the purpose of that testing?
To make sure that the battery temperature sensor would be affected by environmental temperatures, such as being in the freezer, such as being outside, being brought back indoors, and to make sure that the fall and rise of the temperature sensor, at least the pattern would match the expected pattern and would match the thermometer that was alongside it.
When you put the batteries or the phone in the freezers, did it matter what the temperature of the freezer was when you put it in it?
I didn't believe it did.
What was the purpose again of putting it in the freezer?
Just to remove the device from a warm environment, which was outside of the freezer, placing it inside the cold environment of the freezer and just seeing how the temperature dropped.
As you mentioned, you look at data through science, correct?
Correct.
And so, did anybody ever share with you the important points of the decrease in temperature of the cell phone battery to try to influence your results?
Objection, Your Honor.
I'm sorry, could you
Did
rephrase?
anybody try to tell you important points of the evening on January 29th, 2022 in an attempt to influence your studies on the fact that a battery or a phone, when it gets colder, the battery temperature decreases?
No.
So when you developed the graph of the battery temperature, and you followed the progress of that temperature declining through the night, was there any other scope or focus of yours other than to simply track the data?
Just tracking the data.
Similarly, when you looked at healthcare data, were you asked to try to see if the healthcare data could fit a certain theory or argument?
No, I was not.
You were looking at the healthcare data, were you looking at it independently?
I was.
Now, it's not your opinion, or you're not taking a position what the meaning of that data matching up is, are you?
No.
No one's asked you to give an opinion about the coordination of data, have they?
No.
So if the data just coordinates on its own, that has nothing to do with your opinion.
Objection, Your Honor.
I'm sustaining it as to.
You mentioned when you put a cell phone in a colder environment, like a freezer, you noted that the temperature goes down.
Correct.
Do your studies also show that when the cell phone is taken out of a certain temperature and put in an increased temperature, the cell phone battery temperature goes up?
It does.
Do you have available for the screen the battery graph that we had on your PowerPoint?
I do. 2 seconds.
If you could go back one to where it's just the chart, please. And if you could enlarge it, we'll start near the top.
2 seconds.
Okay. At 12:20:43 on January 28, 2023, the battery temperature is 77 degrees.
I'm sorry, that's 8:43 p.m.
That's
all right?
8:43 p.m.?
Yes, the first record.
77 degrees?
Yes.
And if we look down to the last box on January 28, 2023,
Yes.
so at 23:28, that's 12:23:28?
Objection, Your Honor. Move your approach, please.
Okay.
Stop, Sid. Sid, no.
I'm going to ask them. Mr. Whiffen, I'm going to ask you to start at 12:13 on January 29th, 2022. Battery temperature 82 degrees.
Yes.
And now you are also tracking healthcare data, weren't you?
Correct.
You are also tracking location information.
Correct.
At 12:22, the battery temperature is 77 degrees Fahrenheit.
Correct.
And during that time, 12:22, that is the time with the location data where we see Mr. O'Keefe's car traveling near Cedarbrook, isn't it?
Objection, Your Honor.
The form. Sustained.
And at 12:22, on January 29, 2022, where does the location data show Mr. O'Keefe's phone in progress?
It's around Oakdale Road, I believe.
And the travel that you're noting, is that consistent given the speed of being within a car?
I believe so.
And do you know whether or not that car had heat on?
I've got no idea.
You have healthcare data that the phone moves for a 20-second period, right?
I believe so,
And
yes.
That is after the Waze information stops.
Correct.
So you have to watch the form. I know it's hard to orient. You have to watch the
In your PowerPoint presentation, you are tracking the Waze information, aren't you?
I am, yes.
And at some point, that switches to more local location data?
Again, Waze is not recording the location data. Waze is requesting location data from Apple's location services, and location services is doing the recording of the location data.
So if we're following the phone through Waze, at 12:24:25, is it in a car moving at 16.6 miles per hour?
According to the data, yes.
And at 12:24:26, according to the data, is it still in a car moving at 17 miles per hour?
Sustained is to forms.
Can you pull up your PowerPoint, and we'll start at 12:24:25. We can show the jury the progress of that phone.
Okay.
And at 12:24:25, how fast is Mr. O'Keefe's cell phone moving?
The data on the device says that it was moving at around 16.6 miles per hour.
Next page, 24:26.
17 miles per hour.
Next page, 24:27.
15.9 miles per hour.
Next page, 24:28.
14.5 miles per hour.
24:29.
12.1 miles per hour.
24:30.
11.5 miles per hour.
24:31.
10.4 miles per hour.
24:32.
8.9 miles per hour.
24:33.
7 miles per hour.
24:34.
5.2 miles per hour.
24:35.
3.5 miles per hour.
24:36.
3.2 miles per hour.
24:37.
1.4 miles per hour.
And 24:38.
0 miles per hour or 0 meters per second.
And at 24:38, that phone is stopped near the flagpole?
I would say so, yes.
Then the location data gets more broad.
It does.
There is no movement at that time after the car stops. Is there any movement when the car stops at 24:38, between 24:38 and 24:30? Is there any movement indicated on the healthcare data?
Not from the health data, no.
At 12:31:57, does the phone demonstrate any movement?
If I may just look back at my report,
course,
just
please.
to recall. What time was that, sorry?
12:31:57.
Yes, around 12:31:56 or 57 is the start of the health event, 36 steps.
How long? How many seconds does that phone move for?
20 seconds.
12:31:56 to 12:32:16?
Correct.
And is that the only time that the phone moves from the point it stops at the flagpole until the next morning?
Correct.
The only time?
Correct.
12:31:56 to 12:32:16.
Yes.
And when that phone moves, you can't tell if it's walking a straight line or in a circle.
Correct.
You don't know if the phone is pacing back and forth.
Objection, Your Honor.
Sustained as to form.
Can you tell how far a phone moves from its origin, from its original point when you're counting steps?
No. iOS creates the calculation, number of steps times the person's gait, and provides the 25.4 meters value.
At 12:32:16, when that phone stops moving, John O'Keefe's phone stops moving, do you know the next time it moves again?
Objection, Your Honor.
I'm going to allow it.
It's approximately 6:15.
Now, less than 5 minutes later, 12:37, that battery in that cell phone gets another temperature reading, doesn't it?
It does.
Does it go up?
It goes down.
And it goes down to what degrees?
72 degrees.
And over the next 8 minutes, does that temperature even or go up?
At 43 minutes past, there was another reading of 66 Fahrenheit.
And then at 12:53, that's about, what, 21 minutes or so after that phone stops moving? What's the temperature?
I'm sorry, at 12:53?
Yes.
Oh, 61 Fahrenheit.
61 degrees?
Yes.
And over the next 14 minutes, does it drop again?
It does. It drops to 55 degrees at 1:07.
And at 1:36 a.m. that morning,
It's down to 50 degrees.
and this health data shows that that phone hasn't moved. Does
Correct.
this healthcare data show that this phone hasn't moved since
There's
12:32:16?
no more steps were recorded.
Now, you had studies where you put the phone in a freezer.
Correct.
When you put the phone in the freezer, did you wrap it in anything?
I didn't know.
Did you use any type of heat source that would slow down the process of the temperature dropping?
No.
Let me ask you a hypothetical. If a person, a human, was lying prone on a cell phone outside and had a body temperature directly touching the phone, in your opinion, could that slow the process of the temperature decreasing as compared to just simply putting a phone in a freezer?
Objection, Your Honor.
Sustained.
When you put the phone in the freezer, did you wrap it in any warmth,
No.
any clothing?
Nothing at all.
Now, you don't know the temperature, but you said there was a blizzard outside?
That's my understanding, yes.
At 6:06 a.m., is there a change in the battery temperature of John O'Keefe's phone?
Yes, the temperature has dropped to 43 degrees Fahrenheit.
So there's a 7-degree drop in temperature at 6:06.
Correct.
Were you shared any of the facts or information that has nothing to do with data and science? Were you shared any facts or information about what may have occurred to that cell phone and its exposure to colder air that morning, minutes prior to 6:06 a.m.?
I may have heard that around that time is when John was found.
Objection, Your Honor. Move to strike.
Oh, so could you answer the question, yes or no, that Mr. Brennan asked you? Did anybody share information with you about that, sir?
Nobody shared it with me, no.
If the phone was in an environment and it was exposed to further colder air or drop in temperature, could it register a reading?
I'm sorry, can you just ask that again?
Sure. Let me ask a different question. The phone drops to 43 degrees, John's phone at 6:06. 6:14, is there another change with this phone dropping in temperature?
Yes, it drops to 37 Fahrenheit.
Do you know what, if anything, happened as far as the environment that phone was exposed to seconds before 6:14?
I don't know.
Do you know if that phone at 6:15:01 was then placed in a warmer environment, like a pocket or a car? Do you
I
know?
have no idea.
But your data shows at 6:35, there's an increase in temperature,
Correct.
doesn't it?
It does.
So at 6:14, you don't know if there's been any increased exposure, do you?
No, I know that according to the battery temperature, it's increased, but I don't know the reason for that.
Now, if you look at the battery temperature at 6:06 a.m., it's 43 degrees.
Yes.
That's a change in temperature, isn't it?
Objection, Your Honor.
Is that a change in temperature from 136?
It is.
Looking at your healthcare data, is there something happening relative to the phone at 6:04 to 6:11?
There is, that is 432 steps were recorded at that time.
Can a phone record steps if it's being moved back and forth?
It may record some. It's difficult to say how many would be misunderstood as being steps taken.
If you're shaking an object that moves the phone violently, could it record steps?
Again, potentially it could record some, but it's not a consistent enough pattern of movement for it to be recorded as lots of steps.
Now at 6:14, the temperature is 37 degrees, and you just offered us that by 6:35, over the next 21 minutes, the degrees goes up by 6 degrees.
Correct.
You don't know what was happening with that phone at 6:15:01, do you?
I don't.
I'll allow it. Do you know?
I don't know. No.
Next question.
But what you do know is this healthcare data at 6:15:14,
Correct.
and that demonstrates what?
At 6:15:14, it was the start of 180 steps.
So the phone at 6:15:14 is again moving.
Correct.
And after that starts moving wherever the phone may go, it starts getting warmer temperature?
Correct.
Now, you shared with us location data, and you explained the difference between Waze and other types of location data. I had asked you an opinion about where the phone was located, based just on location data, nothing else. And when I asked you that opinion, I didn't ask you to a reasonable degree of scientific certainty, did I?
No, I don't recall.
I asked you if it was consistent
Yes.
with being near the flagpole the entire night.
Objection, Your Honor.
Sustained.
Based on location data alone, are you offering an opinion to a reasonable degree of scientific certainty where that phone was?
It's difficult to say with a reasonable degree of certainty based on the randomness of the location data.
I'm going to ask you to keep your voice up, Mr. Whiffen.
Apologies.
Could we turn the AC off, please? Thank you.
No, it's difficult to give an answer based to a high degree of scientific certainty based on the sporadic nature of the records that night.
Based on the data you have, just on location data alone, is that location data consistent with that phone being near the flagpole area from midnight until 6:15 the next morning?
It is, yes.
There's also information because the broadness that it could have been somewhere else.
Correct.
Yet it is consistent.
It is.
You didn't just rely on location data for your opinion, though.
I didn't, no.
Objection, Your Honor.
Watch the form, Mr. Brennan.
Yeah.
Sustained.
Did you rely just on location data for your opinion?
No, I did not.
Did you also consider the health data?
I did.
And did you also consider the battery temperature?
Objection, Your Honor.
Sustained.
In addition to location data, what are the other things you considered in your opinion
To a reasonable degree of scientific certainty that that phone was at the flagpole the entire night from 12:30 until 6 the next morning?
Objection, Your Honor.
I'm going to allow that.
It was based on the location data that recorded high accuracy, based on the health data that showed when the device moved and how far, based on the battery temperature information, and based on the Doppler face detection information.
Let me ask you some more questions about the health data. You were shown pieces of information on examination. You told us that health data, well, the phone was it your opinion the phone was in the car until it stopped at the flagpole?
Objection, Your Honor.
Sustained.
At 12:31:56 and 12:32:16, does the data show that is the time that the phone was moving?
At what time, sorry?
12:31:56 to 12:32:16.
And sorry, the rest of the question was?
Does that demonstrate movement of the phone at that time?
Yes, it did.
You shared that you can't tell the direction or the distance of steps.
Objection, Your
If,
Honor. I'm sorry, go ahead.
no, please.
Pardon me.
If that phone moved from the flagpole in a straight line away from the flagpole, like for example, towards the house, wouldn't it have to move again before 6:04 to get back to the flagpole?
Objection, Your Honor.
I'll allow it.
I would presume so.
All right, you asking me to strike that, Mr.
Yes, Your
Leslie?
Honor.
Does call register if possible?
No, it's not me.
Jen.
At 12:37, you offered us that the cell phone battery's temperature is decreasing.
Yes.
How many calls have been made from the defendant to John O'Keefe by the time that cell phone battery stops dropping in temperature?
7.
I want to turn now to some questions. You were asked if hash values is one way to do that.
I was.
And you were shown or read part of your report about hash values.
Yes.
There's a second part to that, isn't there?
There is.
You didn't get a chance to share the second part, did you?
Objection, Your Honor.
Sustained.
In this case, there was a hash value, wasn't there?
There was.
Now, just so we can understand simply, how is a hash value created during the extraction process? What does that mean in very, very simple terms?
At the end of the extraction, an algorithm is run on every piece of, every byte of data within the extraction, and it comes out with a value at the end. The idea is that if any of that data ever changes, be it through user interaction or through corruption of data in how it was stored, then that value will change at the end.
You mentioned Gray Key. Is that a software, hardware that makes the copy of the phone?
It's a piece of hardware and includes software.
How commonly is Gray Key used in the industry?
It's very common.
Did I hear you say that with Gray Key, the hash value is never authenticated?
Objection, Your Honor.
Sustained is to fall.
Does Gray Key authenticate the hash value?
The hash value is placed inside a PDF which is not signed.
And is that common or typical in the industry?
That is the way that Gray Key do it.
Was there anything anomaly or untoward or different about the way this one was done?
No.
Did the hash value from the Gray Key extraction match the hash value?
It did.
Anything irregular whatsoever about it?
No, not that I could see.
Now, you don't just read software programs when they spit out reports, do you?
No.
As an analyst, as one of the leaders of Celebrite, do you have a history of being a researcher?
Yes, I do.
A history of study?
Yes.
Have you written reports and papers for people to learn?
I've written multiple blogs, done multiple presentations, webinars. Some of my blog posts have become peer-reviewed articles.
Okay. Is it sufficient to simply look at a report that is generated by Celebrite or Axiom or any other service and make conclusions just on the report?
I don't believe it is, no.
Why do you think that's imprudent?
Yeah, sorry?
Why do you think that is not prudent to simply rely on a report?
Objection, Your Honor.
I'm going to allow him to answer.
The tools are very good at surfacing data, but I believe it's up to the examiner to understand what that data means and to provide context to the information which the tool itself can't give.
And when you were considering the hash value and determine whether or not you thought there was anything wrong with the data, aside from the hash value, how do you do that?
How do I do
How
what?
do you make a determination whether or not this has integrity, the data hasn't been tampered with, so to speak?
Okay. So notwithstanding the hash value, I'd be looking for issues with the data that don't make sense. In this particular case, there was lots of data points that all appeared to work together. Like you would see one artifact change in one database and an artifact would change somewhere else. And it all just made perfect sense in how it was functioning. That kind of leads you to believe that it's not been tampered with, or the person tampering with it did an exceptional job to be able to cover all of these different tracks and make it undetectable.
Did you try to summarize that perspective in the part of the report that wasn't read to you on examination?
I did.
Do you have an opinion to a reasonable degree of scientific certainty if there was any data integrity issues in the information you reviewed?
I don't believe there was any.
It was characterized on examination, there was a dispute about the time origin of the search, how long to die in cold. Do you remember being asked the question about a dispute?
Yes.
Have you, in your studies and in your position, is there any viable dispute in the forensic data scientific community about that issue?
I don't believe there is anymore.
Now, you got involved in this case because you received a complaint from a consumer.
I received a question from a consumer, yes.
And you attempted to resolve that?
Correct.
Sustained is to affirm.
Other than that source, have you received any information, feedback, opinions that would make this issue in any way a dispute?
Objection, Your Honor.
I'll allow that.
I'm sorry, could you rephrase the question?
Other than that one person, that one consumer, have you received any information in the forensic community which you're part of?
Oh.
Any data, any information that would suggest that your conclusions are in dispute?
Yeah, I received a very similar question from an examiner in Europe. Fairly similar circumstances with a case and with a timestamp that didn't make sense, that was originating from the same database. I applied the same logic and theory to his question, and he confirmed it solved the issue for him. It all made sense then.
And since then, has in your world, academic and research world, forensic data science, other than the person who originally raised the question, has there been any dispute brought to you by anybody about your conclusions about when this search actually happened?
No. If anything, I've heard people who have confirmed the research that I did.
Do you know Jessica Hyde?
I do.
Is she well known in the forensic community?
She is.
You were asked questions about your law enforcement background and the fact that Celebrite is used as a forensic tool oftentimes by law enforcement.
Yes.
Did you go into your company's software and change it to accommodate law enforcement?
No, definitely not.
Would you ever do such a thing?
No.
Why wouldn't you do something like that?
Aside from being unethical to change the data in that way, this is an artifact that is easily validated by any examiner. And if I was to tamper it for the purposes of changing the outcome of a case, it would be detected by all of our customers immediately and would destroy the reputation of Cellbrite, which I've got no intention of doing.
Before a prior proceeding, the printout from the software, when it was showing the timestamp of the Safari search, was it labeled something in particular before?
The Cellbrite search
Yes.
was labeled last visited time.
Last what?
Last visited time.
And when it was labeled last visited time, did it show 2/27 on the report?
It did.
Cellbrite, after research and consideration, removed that label?
We removed the timestamp when we determined that it was not relevant to the last time that that page was visited.
Why was it important to remove that timestamp from the program and the software?
It was clearly causing confusion.
Does the company have concerns when consumers are confused about information?
Of course, yes.
Do companies have concerns if a consumer tries to manipulate the use of that information?
Of course.
Are companies concerned that a label could be misleading for somebody who may not have a higher level of experience?
Yes.
When that decision was made to change that for clarification, do you make that solely by yourself?
No, I did not.
Who do you consult with and who's part of that decision process?
So again, after my research, I passed the results of my research to the Forensic Research Group. This is a team based at Cellbrite whose sole job is to do the research, do the coding to make sure that what we're giving to customers is correct, They spent some time validating the research that I did, verifying that my research was correct, and then they were responsible for making the change based on the updated research.
It was suggested that a separate software program, not the company you work for, Celebrite, but Axiom reflects this search as deleted. That's not entirely accurate, is it?
Objection, Your Honor.
This search as deleted?
Yes, and it is a deleted search.
Does it have a label on it?
It does.
Is that carved?
Yes, it would be.
Now, are you familiar with the Axiom Artifact Reference Guide when it talks about the dangers of relying on the timestamp?
I'm not familiar with it referencing dangers, but I'm aware of the document.
Are you aware of the reference guide when it talks about Safari suspended state tabs?
Yes.
And offers that since these are local tab states, results from this artifact may contain an earlier date and time compared to the results in the Safari history artifact if iCloud Safari synchronization?
Objection, Your Honor.
Sustained.
Are you aware of the reference guide?
I am.
Are you aware that it cautions that a timestamp can be misinterpreted?
Objection, Your Honor.
Sustained.
Sir, when you came to your opinion that the search for how long to die in the cold at 6:23 and 6:24 on the morning of January 29, 2022, was the time that they were actually inputted, not 2:27. In forming your opinion, did you consider both Celebrite and Axiom software?
I did.
Did you consider other tools as well?
Yes, my own.
And tell us a little bit about your own tool.
Again, this is a tool I've been writing for approximately 5 or 6 years now. Partially for fun, partially for research purposes. And it's a tool I make available to other examiners globally.
And sir, when you were trying to examine these searches that in your opinion were 6:23 and 6:24 a.m., did you ever try to test it yourself and actually take a phone so you could either prove or disprove to yourself that that earlier timestamp didn't mean it was the time that it was searched?
Oh, definitely. That's the kind of thing I do all the time when verifying artifacts.
And in your opinion, is that helpful in understanding how a timestamp earlier could relate to a later search?
Exactly, very helpful.
Would you be willing to do a live demonstration for us on the screen and show us how that works?
Yes.
Okay. How long would that take?
Probably about 5 minutes.
Okay. Could you show us?
Of course.
Okay. Seems like a good place to take our lunch and recess, 45 minutes. Okay. Mr. Whiffen, I'm going to ask you to read the report, but the rest of us are in recess.
Please rise for the jury. Please leave your notebooks on the chairs. Thank you.
Jen, I don't think the marks were from the taillight. He could have hit his head on the fire extinguisher. And I don't know, what if maybe the snowplow clipped him? And that's where, I don't know, the marks came from? I'm gonna run and get some tacos. I can turn over to Law and Crimes Court, lunchtime court chat, or I can turn it off. Do you guys have a preference? Let me know.
In a moment.
with regard. A case. Your opinion has no relevancy to the topic of where a phone might be to investigators in a case? Is that what you're saying?
Is that what you're saying, Mr. Whiffen?
I'm saying I can't take a temperature reading and make a determination about a GPS location based on the temperature reading.
That's not my question, though,
Okay.
sir, and I appreciate your answer, though.
So, Robert Alessi later followed up, and then he conceded, Ian Whiffen did, that this battery temperature can be relevant in determining the location of a phone. Obviously, the defense is saying this phone at some point could have been in that house on Fairview Road.
Right. And I think that's kind of the main crux of it, right? Is the temperature dropping at a rate that would make you believe that it was outside this entire time, or was it inside the house at some point? And I think he has to concede that it's relevant for that issue. He did experiments to determine whether or not it was going to be relevant. And I think he didn't testify to them on direct because when he did his experiments, that temperature dropped dramatically faster than it did when you look at John O'Keefe's phone and the data that was extracted from it. So they didn't touch it on direct, they hit it on cross, and now they need to rehabilitate him on redirect.
Yeah, and Hank Brennan is doing that. He's working to do that because that's what attorneys do. So let's get to some of your questions. Keep those questions coming in. We're going to take as many of them as we can during this lunch hour, and then we'll get to some of the cross that had to do with the 227 Google search. So that was pretty interesting stuff, too. This first question is from enginerd_13. What temp did they say the phone was at when it started to read movement? I don't know if you recall the exact temperature, Austin, but there were various temperatures, and I don't know exactly when they're saying movement, whether they mean after 6 a.m. or beginning in the morning or in the evening. But do you recall the exact temperature when it started to move? I saw the chart yesterday.
I don't recall the exact temperature, but I think what we're seeing now on the redirect from Attorney Brennan is lining up when the phone moved from the car and what the temperature was at that time, and then when it started to drop, whether or not there was further movement of the phone after the temperature starts to decrease and never starts to increase again. So when he lines those two things up, you have a phone moving from a warm place outside, presumably to the cold, the temperature dropping, and the phone not moving anymore. That's some pretty strong evidence to suggest that John O'Keefe never went inside that house, or at least his phone never went inside that house.
Yeah, and then after 6 a.m., there's that sharper drop, and then the temperature starts to go up again, presumably when Carrie Roberts picks up the phone and puts it in her pocket. Question ND says, don't you think that all of this has confused the jury so much that they have tuned out? I was kind of wondering that earlier today because they had a lot thrown at them yesterday with Ian Whiffen's testimony on direct, which seemed to be broken down. And, it was a little dry. I mean, it gets tedious. But then now they're hearing all of this new stuff on cross. But what do you think about that? Do you think that the jury might be a little lost in some of this?
Definitely. I think that anytime you're putting on a forensic examiner, you're going to be talking about science and things that are not intrinsically interesting to sit there and hear people talk about. So it's boring at baseline. And then once the defense got up there and started their cross, I think a lot of the motivation there, a lot of what their goal is to muddy the waters. Make it seem like you can't trust any of this stuff. Nobody knows what it all means. And it's confusing at best, so throw it away. But now with the redirect, I think, again, Attorney Brennan is going to come in and try to clarify that all and wrap it up and put a nice bow on it. And of course, at closing is when he's really going to be able to bring it home. So they may be confused now, but hopefully by the end, he'll be able to clarify it.
And that often happens. And it sounds like they're going to call the other witness too. Hank Brennan on redirect asked, do you know who Jessica Hyde is? And Ian Whiffen said, yes. Is she well respected? So I'm assuming we're going to hear from her again too. Let's just the poll results from our first poll. We had put that first poll up asking if Ian Whiffen was a credible witness. Our final results with 2,500 votes was no, 61%, and yes, 38%. So that is from our voters in the YouTube chat. So our next question is going to be from Pixie. How credible can data be when the actual environment, circumstances, or locations isn't given? That's a pretty good question, Austin.
It is, and I think we heard some testimony about that. There was testimony about location data being impacted if you're inside of a house or a garage, or if you're in extreme weather conditions, which this phone was. So how accurate is, can you pinpoint, yeah, he's right next to a flagpole on this second, and then he moves over here a minute later? Probably not. And I think that's what a lot of the cross got into, and that's probably accurate. This data maybe isn't as accurate and precise as what the prosecution wants to paint it out to be.
We have another poll that we've put up. Do you believe John O'Keefe's phone was outside with him that night? Right now, 56% are saying no. So we're going to keep that poll up for a little bit. So we'll see what the final results are from that. But our next question is from Roxy. What are your thoughts on the 2:27 a.m. versus the 6:23 a.m. Google search, house long to die in the cold? What's the actuality? So what do you think about that, Austin? I mean, have you made up your mind definitively based on what we heard in the first trial and now what we're hearing in this second trial about whether or not you believe it was 2:27 or 6:23?
I tend to think that it was a 6:23 search, and that this concept of opening up a tab and that being the timestamp on that tab makes sense. I don't think that it's as nefarious as what the defense wants to make it out to be, which is somebody either tampered with this or that the search actually was made at a different time. But I think it's good for the prosecution to be able to get out ahead of it and get that testimony out up front and explain it away as much as they can. I think that's incredibly important because anytime you can raise confusion on the defense side, that's going to be good for you.
Yeah, I always found it so interesting that the defense's expert, called, Celebrate and said, hey, what's going on with this? I'm getting this 2:27 result. And so then they go back and they look at their stuff and tweak it and things like that. So this whole 2:27 search is really one of the cornerstones of the defense theory in this case. If it happened at 2:27, then their conspiracy, has legs. If this house long to die in the cold happened at 2:27 a.m. So that was a major point of contention on cross-examination this morning with Robert Alessi and Ian Whiffen. So let's take a look at that.
In the first proceeding in this case, in June of 2024, when you testified under oath, the situation with the forensic tools was Celebrate Forensics Insights did not show the 2:27:40 a.m. timestamp, but another version of Physical Analyzer did show it, correct?
Correct.
In that second program, that second tool, Physical Analyzer, not only showed it at 2:27:40 a.m., but it showed it as a deleted state, correct?
It's a deleted record, yes.
A deleted record.
Yes.
Did you mention that yesterday in your direct testimony?
I don't believe so.
You don't believe so?
No, we changed it since then.
Exactly, you changed it since then.
Yes.
Your company removed it
Yes.
after the first trial.
Before the first trial.
Well, you removed it from one tool before the first trial, but you didn't remove it from the other physical analyzer program, did you?
Up until the following version was released.
No, I'm talking about the time of trial when you were testifying.
I appreciate that. There's some complexities with how we released the software, which resulted in one being released several weeks later and one being released several weeks earlier.
At the time of trial,
yes,
last year in June, when you were testifying under oath, one of the Celebrite tools showed the timestamp of 2:27:40 a.m., correct?
Correct.
But that timestamp doesn't exist anymore, and it doesn't exist today, does it?
Correct.
Celebrate removed it.
Yes.
Search at 2:27 or 6:23 a.m. So everybody vote. Austin, what did you think about that little bit of cross-examination about this very point? The defense is hammering away at the fact that Celebrate removed this. So Celebrate is saying it was 6:23 that this happened, not 2:27. The defense is sticking with the 2:27 search. So what did you think? Did you think Alessi was effective there?
I didn't find him effective there. I thought that was very good cross-examination. He's back on his heels. He's trying to say, we released this software and then we released this software. He's trying to explain himself, but he really couldn't. And then you have this whole aspect of the search itself being deleted. And I don't think that ever got answered. Why would that search come up as a deleted search? His explanation on that point seemed very weak as well. So I found that to be one of the most effective areas of cross-examination.
Interesting. Yeah, I mean, it seemed like Ian Whiffen was getting kind of uncomfortable up there at points. And it has to be uncomfortable, especially when, Celebrate, when you hear about the software in the industry, Celebrate seems to be like the gold standard. But then now you're seeing that maybe it's not always right in their own estimation. So, I mean, this really could turn out to be a battle of the experts on this point. Who will they believe? Ian Whiffen with Celebrate or Richard Green on the defense side?
Right. And with this much spotlight on this trial, to be up there representing a company and saying, well, maybe we messed it up the first time, or maybe we got it wrong that time, but we're getting it right this time, that's just a really tough look for Celebrate.
And we have a question from John Lennon, of course, not the John Lennon, but John Lennon asks, PR nightmare for Celebrate, no, product bad?
Right, I think it is. It is kind of a PR nightmare because as an attorney, when you see somebody up on the stand being raked over the coals the way that we're seeing them be raked over the coals right now, that'll give you pause next time you need a forensic analyst. You don't want to put somebody up there if they've had a hard time during cross in the past. You want somebody who's going to be able to stand up to cross-examination. And I'm not sure on that point, that's what we saw today.
Well, let's play another clip about the 2:27 a.m. Search. And this is another exchange between Alessi and Ian Whiffen. So let's take a look at this and we'll talk about it.
Celebrate outright removed the timestamp from so none of its programs had, correct?
Again, if I could explain a little bit about how it works.
No, I'm sorry.
Okay.
If you could just respond to my question. Is that correct?
The timestamp's been removed, yes.
However, the competitor of Celebrate that we just talked about, Magnet Forensics Axiom?
Yes.
That program at the first proceeding showed the 2:27:40 a.m. timestamp, correct?
Correct.
And as a matter of fact, as you sit here today, the Magnet Forensics program, Axiom, still shows the 2:27:04 a.m. timestamp, correct?
As far as I know, yes.
And Magnet Forensic Axiom is a reputable company, correct?
Correct.
Celebrite removed that 2:27:40 a.m. timestamp, which was in a deleted state, in response to issues raised in the first proceeding, correct?
It was changed because of the research that I did, and that was verified by the forensic research group.
But the issue arose because of what had come up in the first proceeding, correct?
In the first investigation prior to the proceeding, yes.
In the first investigation in this case, correct?
Yes.
So Celebrite, after the first proceeding, after the investigation, just outright went and removed the timestamp.
It's not unusual to change the
I
code.
didn't ask if it, I just asked whether
Yep,
they
we removed it.
But Magnet Forensic Axiom still shows that 2:27:40 a.m. timestamp, right?
Again, they refer to it differently, which is why they can
But
do
they
that.
still show it.
They do still show it.
I don't know, Austin. You know, it was a really uncomfortable moment because Ian Whiffen is saying, yeah, I work for Celebrate. We made this change. He's conceding that Axiom, the other group, is a reputable group. But he's trying to explain why they made the change. So in the end, is this all going to come down to whether or not the jury believes Jen McCabe?
Yeah, it could. If you have a battle of the experts and they wash each other out, that's what it comes down to, right? But right now, the way that this testimony came out and the way that that cross point hit, it was not a good look for Celebrate at all. When you don't own something on direct and then they hit you with it on cross-examination and you're back on your heels admitting that you deleted something and changed something, the jury's sitting there wondering what you have to hide and whether you can be truthful or trusted about anything. So it's just a real rough area of cross for him to have to go through there.
Yeah, it's really rough. And I want to give the results of our latest poll. Our latest poll asked, do you think the Google search happened at 2:27 or 6:23? And 79% of our people voting in the poll said they believed it was 2:27. So there were 2,000 people who voted in our poll. So let's get to more questions now. Jasmine Mirage asks, if the search was really made at 2:27 by Jen McCabe, would they put her on trial based on this information?
That's a good question. And I don't, on trial for what, I guess, is the first question. If it's a question of whether or not they're going to look for another suspect, if Karen Reed is found not guilty, I think the answer there is no.
No, they've made it clear this is who they believe did it.
Clearly, they believe that Karen is the one who did this. So I don't think we're looking at anybody else there. Is she going to be looked at for other things? Could she be looked at for perjury, things like that? Maybe, but probably not. I think it's just going to all be determined at this trial one way or the other. And I don't think that Ms. McCabe is going to face any prosecution herself going forward.
And correct me if I'm wrong, Austin, but Jennifer McCabe and some of these other people handed over their phones to be analyzed. That's how we have this information in the first place. So shouldn't we have some data about the location of her phone at 2:27?
Right. You would think that they would know that information and that would be out there. So presumably it's going to be in her house. I don't think that there's going to be a dispute over where she was or where her phone was, is whether or not she made that search at that time. But there are other things going on her phone around the same time. So you know she has it. You know she's looking up the scores.
Right, she's looking up the basketball scores or whatever. And I guess I'm just looking at why would, if she's doing this search at 2:27, why is she doing it? And who's asking her to do it? Unless she's just doing it on her own volition. What's the theory there?
Right. I think that the defense's theory, or what they're trying to put out there, is she knows there's a man out on her front lawn in the freezing cold, and she wants to know if he's going to live through the night. So she's looking it up at 2 a.m. But to do one search like that and then move on to what are the scores of my kids' games and things like that, it just doesn't mesh with me. Which is why I tend to skew towards it was a search made in the morning. But I think, again, I think it may come down to we don't know when it was made. We have a battle of the experts, and maybe the jury just throws this all out and looks at the testimony coming from the witness stand.
Let's go now to another question. This is from PS. If Jen is so guilty, why Karen called her to look after John? Why she would follow Karen if she was part of a plot? That's an interesting question. So PS is basically asking, if Jen was part of this, why is she, tagging along with Karen to go find John? If she's part of this conspiracy, was that part of the plan? I mean, how did they get Karen Reed to wake up and think, oh my gosh, I've got to call Jen McCabe and Carrie and get them to go with me to find John?
Right. And that is a good question. And from Miss McCabe's point of view, if you are involved in some conspiracy and you know that you have a body on your front lawn and it's going to be Karen Reed that the finger's going to be pointed at, why pick up her call? Why get involved with it at all? Why not just stay away and let things play out? So that's a good question. And the answer is, I don't know.
And it was Jen's sister's house, I believe, where John's body was, just to clarify, just so we have that clear. This next question is from Chloe Kramer. Wait, so if she's found not guilty, then no one gets held responsible. They just won't look at other suspects. Case closed. I mean, basically, yeah. I mean, they if she's acquitted, this is who they believe did this. I mean, they're not going to go arrest other people, Austin. The Commonwealth believes Karen Reed backed her car into John O'Keefe and killed him. So they're not going to go out and investigate. That, as far as they're concerned, they've done their investigation.
Right. They're not going to reopen this case and start investigating other people. I mean, if you play that out, how would that look at a trial against somebody else if the Commonwealth has already tried Karen Reed twice for this case and wholeheartedly believe that she's the one who did it? That's going to be a defense attorney's dream if you try to turn around now and point the finger at someone else, unless you have really damning evidence with which to do that.
Yeah, our next and if you were on trial, you could just say, "Oh, there's my alternate suspect, Karen Reed." Yeah, it would just be a disaster. Here's Sybil has our next question. How was Karen able to run John over and then be home 4 minutes later in a snowstorm? Why didn't Jen see Karen hit John with the car? Sybil's got many questions here, so let's break it down and start with the first one. How was Karen able to run John over and then be home 4 minutes later in a snowstorm? So I guess Sybil's concerned about how did this happen so quickly?
Right. And it's hard to pinpoint exactly the timeline there. I'm not quite sure what the time was, but presumably she would have hit John with her car and then driven right home. So I don't think there's anything in between there that is being pointed at by the Commonwealth saying, oh, she went here or she went there in between these two events.
And it had just kind of started to snow. I don't think we're talking inches of snow just yet on the ground at that point. Our next question is from Eugene Wood. Why would a cop kill a cop and leave them on their front lawn? I mean, that's my question. I'm like, if you're a Boston cop, and you've got an ATF agent in the house too. I mean, that's always kind of been one of my big questions. I mean, can't you come up with a better? I mean, if you're supposed to be, I'm speaking hypothetically here. If you're supposed to be such a corrupt figure, shady figure here, you can't come up with a better way to handle this than to throw a body on your lawn. It does seem a little bit absurd, and then you're going to pin it on the girlfriend of the person who has passed away.
Right. And that's always been a point that I got hung up at as well, because you would think that they'd be better at covering their tracks if hypothetically someone in that house had killed John O'Keefe. You don't think they would just drag him out and leave him on the front lawn. I don't see how they could know that they were going to pin it on Karen Reed at that point. either. It seems like it would all have to have happened so quickly. But taking a step back, you have to remember it's not the defense's burden to prove that that's exactly what happened. All they have to do is poke holes and say that the Commonwealth hasn't proved their case beyond a reasonable doubt. So for purposes of this trial, they don't have to uncover every rock, nor should they. They don't have the resources of the Commonwealth. So while that may seem like a far-fetched, corrupt scheme that the defense is kind of painting, they don't have to prove it. They just have to poke holes.
They don't have to prove a thing, actually. And you make a very good point there. The defense doesn't have a burden at all to prove anything. It's really interesting to me because we're so early in this trial, Austin. It's only been going on now for about a week, and at least the witness testimony. And we're still very early on in this case. I mean, we haven't even gotten to the testimony of Michael Proctor yet, who really is somebody that is not going to be great when he gets up there. It's not going to be good for the Commonwealth's case when he gets up there and he starts reading his text messages to his buddies, and the jury hears, and they've already heard in opening statements from Alan Jackson, that he was fired for an appearance of bias. So it's not going to look good for the Commonwealth, and I'm going to be interested to see how Hank Brennan handles that on direct.
Yeah, I think what we've seen up to this point is probably the Commonwealth's strongest case. They're trying to put their strongest case up front, and then in the middle, they'll put their weakest pieces, and then they'll buttress it with some strong evidence at the end of their case. But we haven't gotten to the stuff that's going to be really good for the defense yet. So you could see the tide changing a little bit once we get into those witnesses like Mr. Proctor.
Yeah, it'll be interesting to see how that goes because he was suspended last time. This time around, he's going to be fired and disgraced, really. Let's get to some more of our questions. This one comes from Scream Queen. When is Jen in court? Anyone know? Well, we were thinking today. She is at the courthouse, so we saw her arriving. So we believe Jen McCabe will be coming up after Ian Whiffen, and we'll see if his redirect ends after lunch, sometime after that. Our next question is from New Hampshire Law Mama. If there is another mistrial, do you think the CW will go for a third trial? Austin, what do you think of that?
I think they may. It's such a high-profile case with a dead police officer. I don't see them giving up on anything. And then the flip side of that is there's always this question of, will we have a plea bargain? And would Karen Reed plead to something? And I don't really see any signs from her team saying, oh yeah, we're willing to make a deal on this. So if you end up with another mistrial, you may end up with a third trial. I just don't see either side backing down.
Mm-hmm. Yeah, and I in that docuseries on Investigation Discovery, I finished watching it over the weekend, and it was on HBO Max now. And one of the friends of John O'Keefe said that basically the Commonwealth has told them they'll try this case as many times as they have to. So it sounds like, at least according to that gentleman, he's been led to believe the Commonwealth is all in on this case, and they will take it to trial as many times as they have to until they get a verdict. So I want to mention, though, you guys, in case you didn't know, we have a great new podcast out. It's called Karen the Retrial. It just dropped yesterday on Wondery Plus. It's also available on Apple Podcasts. And this is a recap of the retrial. And you can get everything that's happening on this case there. The first 2 episodes are out. And then there will be other episodes coming out as well. So you might want to check that out. Wondery Plus and Apple Podcasts. Great podcasts. So if you're in the mood to listen to more of this after the day ends or even while the trial's going on, which you should be just watching it here while it's going on. But if you are in the mood to check out a podcast, check that one out and keep those questions coming to us. Our latest poll was, at this point in the trial, where do you stand, guilty or not guilty? And the results were 81% saying not guilty. So that's what our poll participants are saying at this point in time. Our next question comes from David. Do you think Ian Whiffen is acting more as a defense expert for Jen McCabe? He said nothing that shows Karen Reed hit John. Well, that's not really his job, though, Austin. I mean, he's presenting phone data.
Mm-hmm. Right. He's not supposed to be an advocate for either side or for any of the witnesses in the case. I think he's just there to testify about what the forensic data shows, or at least that's what he needs to say his role is in this case. So if he got up there and he said, yeah, I'm an advocate for the defense or the prosecution, then that would be a problem. Obviously, that would go to his credibility and it would destroy him. So.
Our next question comes from Kay Young. How can this even go to trial when the investigation was found to be corrupt? Well, I mean, the investigation hasn't been found to be corrupt. Proctor was fired. So I think that the question about whether the investigation is quote unquote corrupt, that's a question for the jury to answer.
Right. And the investigation hasn't been found to be corrupt. What the investigation certainly, I think, has been shown to have been is sloppy. And I think that's given the defense a lot to work with. If you have somebody who's not Michael Proctor on the stand and somebody who was an upstanding police officer who kept his job and behaved appropriately, then I think the defense has a much harder battle moving forward. But the trial can go on. The investigation hasn't done anything that has led me to say, oh no, this woman can't be tried. But the way in which it was conducted has certainly opened a lot of doors for the defense. So that's the problem with the investigation, I think.
Yeah, and I really think the biggest, part of this for them, is Michael Proctor. I think that is the biggest, part of this for them. Their big enchilada, if you will. He's the Mark Furman of this case. So I think that the fact that he's been fired and they found, this Massachusetts police investigation found that he gave the appearance of bias, that's enough for them to put him up and say, look, this is who was in charge. You got a guy texting with his high school buddies about her and calling her all these horrible names, on the night, the first night of this investigation. I mean, it's just really bad.
It is. It's a terrible look. The fact that he has been fired, it almost cuts both ways because you can say, well, it's not the whole department. It's just one bad egg. And we got rid of him. And we understand that this was bad in this investigation, but we dealt with it. And this is what the evidence is now. But he is certainly a hard witness for the Commonwealth to have to put up, especially as the guy who's supposed to be your star. He's supposed to be quarterbacking the whole thing, and that's who you have. But unfortunately, that's who they're stuck with.
Yeah, I mean, it's what they've got, and they've got to just deal with it. Our next question, and guys, obviously we're on a lunch break right now. Court is going to resume at 1:45, so we've got about 8 minutes left or so. So keep your questions coming in. This is our next question. This is from MoCat. What if I don't want my tax dollars going to unending retrials? That's a pretty good question, Austin. If you're a taxpayer in this county and you're kind of like, I don't like this. I don't like that they're spending so much money on this. What do you do?
Right. And unfortunately, I don't know that there's much that a taxpayer could do. I mean, you can contact your representatives and everything. But again, I think what the concern is a valid one. Because not only are the resources being expended for the trial itself, all the added security, all the court personnel, the judges, but now you have Hank Brennan coming in as a special prosecutor who's been hired. He's a defense attorney, basically, but he's being paid by the Commonwealth to come in and try this case because obviously they had a hard time doing it on their own the first time. So that's even more money being expended. So it's a valid concern. But unfortunately, I just don't see this as being a thing that's going to go away unless and until we get a jury verdict.
Brandy Reitz has another question for us. Did the Commonwealth pay Ian Whiffen? Was he compensated? So Austin, Celebrate, he works for Celebrate. So, does the Commonwealth send an invoice to Celebrate for Ian Whiffen's testimony for his work?
Yeah, if he's a third-party contractor, he's not going to work for free. But conversely, the defense witnesses, they don't work for free either, the majority of them at least. So that's where you end up with the battle of the experts, and usually both sides are pointing the finger at the other guy and saying, you're only here as a hired gun. You're being paid X amount of dollars, and that's why you're saying this. But you have that coming from both sides, so it ends up being a wash, usually, in the battle of the experts.
And just to touch briefly on the fact of, or on this issue of experts being paid or not, this came up yesterday, kind of, with the ARCA hearing. What were your thoughts? What were your big takeaways on Dr. Wolf's testimony during that hearing with ARCA yesterday? Because, the Judge Canody, allowed this voir dire because she felt that there was an intentional discovery violation. Dr. Wolf gets up there on the stand. They were sold to the judge in the first trial and the jury as completely independent. They were doing something for the feds, weren't being paid by the defense, that type of thing. And yet we find out later that that wasn't true. They sent a bill after the fact, to the defense for, $20,000 or what have you. So how did you think that went? Because depending on who you listen to and who you see on social media talking about this, two very different perspectives on how this went yesterday. Everything from nothing burger to, Hank Brennan really, got some good information out of Dr. Wolf and it looked really bad.
Mm-hmm. Yeah, and you're going to see that through whatever lens you want to watch the trial through, whether you're pro-prosecution or pro-defense. It is concerning when there's an allegation that an attorney is misleading the court or hiding things that should have been turned over in discovery, especially when then you end up with ARCA representatives taking the stand and saying that they're communicating through Signal and they're deleting text messages and getting new phones. That's all over this trial. It seems like nobody has the same phone that they started this case with anymore. But as far as yesterday, I think Hank Brennan did a pretty good job. He was obviously fired up. He came out yelling, a loud tone of voice, very authoritative. But when you boil down what the questions were and what may have been hidden, I didn't really think there was much meat to it. And I think at the end of the day, ARC is going to be allowed to testify. I don't see a situation where Judge Canoni is going to keep them out of this trial, although some judges may. The sanctions for discovery violation can be pretty harsh. But again, with ARCA being such a big part of the Reed team's defense, I don't see how she can totally keep them out at this juncture.
Yeah, my only thing with this was, why are they talking on Signal? I mean, why is this necessary to talk about logistics and travel arrangements and all of this stuff? And then, Dr. Wolf saying he's giving him advice on what to ask him and things like that. And it just sounded like not what was represented at the first trial. So that was my kind of thinking on it. Like, wow, this doesn't sound like how they were represented at the first trial when they came in as being just completely independent. And then we found out later they got paid. So I don't know.
And for purposes of the prosecution now, all of that information's out there. So they're going to come across a lot differently in this second trial than they did in the first trial.
Yeah, definitely.
They're exposed to cross on all of that stuff.
So let's go to our next poll question, and we'll get to more of your questions. Who is more compelling? This is our next poll question, guys. So vote on this in the chat. Hank Brennan or Alan Jackson? And then we'll give you the results of that just in a few minutes. But here's our next question from Eddie Campbell. Could Karen's deep involvements, at times appearing more like co-counsel than a defendant, shape the jury's perception of her guilt or innocence consciously or subconsciously? That's a pretty good question because she is very, very involved. I mean, this is an intelligent woman who was a college professor. So, Austin, what do you think?
Yeah, she is extremely involved, much more so than a lot of my clients, possibly more so than any client I've ever had. And you see it in that documentary series as well. Behind the scenes, you get a look at her in these meetings with attorneys, strategizing with them, which oftentimes doesn't happen with a defendant in the room. And then in court, you see her attorneys going to her and her whispering questions that she wants them to ask. Again, you don't see that very often in a courtroom. So I guess to get to the question, how does that impact what the jury's seeing and what they're thinking? Somebody that involved in their own defense, it could cut either way. It could be, wow, this person really has it together. They're on top of things and they're participating in their defense like I would expect them to. Or it could be she's orchestrating something and it's something shady's going on here. You just never know what lens the jury's going to look at it through.
Yeah, you really don't. And I wonder what they think of her going up for the sidebars, too. You know, and they may think nothing. I mean, if they're first-time jurors, they may think this is totally normal, no big deal.
Right. But to your point, it is extremely abnormal. I mean, again, those
it's not something you
there
see.
are things that you expect a defendant to participate in and things that you don't. That's one that you don't really see a defendant participating in.
Yeah, you don't see that a whole lot. So, you know, one thing that's come up a lot, and we were just talking about the docuseries in this case, Austin, is Karen Reed's statements. And there are a whole lot of them. And they've come in this trial, and we've seen a lot of them that just, they don't look like they're helping her out a lot. The Commonwealth is presenting them. And so she was asked about that before opening statements began, several days before opening statements. So let's take a look at what Karen Reed said, and then we'll talk about it.
Karen, how do you feel about the jury being here? Stay.
Please. We're loaded for bear, ready to get the show on the road, and we're happy with the whole process today, this
Karen,
week, last 2 weeks.
How do you feel about Hank Brennan planning to use your interviews in his opening statement?
Come at me.
That's what your dad said.
Sound like your dad.
I may have seen it. I would not have said anything that I wouldn't say again.
Are you pleased? Like to have more time than openings Tuesday? Did you guys originally hoping to get more time?
We're ready right now.
Are you happy with these jurors, these 9 men and 9 women?
Very pleased, absolutely. Yep, and I believe they're truthful and they were questioned thoroughly. So I have confidence in that.
Do you think you might testify this time? There'll be no comment. Are you feeling confident about your case?
Always.
Can you feed that as soon as possible? Thank you.
So update the network.
Who is producing that? Is Jim working?
Okay, Austin, she said, come at me. Well, they've come at her. They've played quite a few of these statements. We haven't seen any, today at least, but she said, come at me, and they did. So what do you think of kind of that bravado that she projects to the press?
One of the hard and fast rules that I think a lot of defense lawyers live by is you, my defendant client, should say nothing to anybody, and especially not on camera. Because when you say it, even if you think it's true or you think you're helping yourself, the prosecution is going to use it in a way that helps them. And we saw that in this trial with them calling John O'Keefe's mother, putting a very sympathetic witness on the stand, and then immediately playing a clip of Karen Reed impersonating her in a very non-flattering way. So they are coming at her, and they're coming at her with things that are not going to help her at all. It's hard when you make statements on camera because they're going to be used against you and they're not going to be used in a way that you like. So I think she's kind of dug herself a bit of a hole making all these statements to the press.
And we'll have to see what the impact is. Only time will tell. Only time will tell. Right. So, Austin, we are going to return to court here very soon, within minutes. And Ian Whiffen will be back on the stand where redirect will continue. You kind of felt at the beginning of our conversation today that Hank Brennan was cleaning up some of the damage that maybe was done on cross. Is that going to continue? Can that damage be undone?
Yeah, I think the main thing for Hank Brennan to do now is to get the timeline right and try to clean up and unmuddy some of the waters that the defense has been able to muddy here. And I think he's going to continue to do that throughout the rest of his redirect.
And then I think we're going to see Jen McCabe on the stand. And I think that's why, there's been so much focus on the 227 search here, because it sets the table for Jen McCabe to come in and say, this is what happened, and this is when I did that search.
Right. And depending on the way that this remainder of the redirect and recross goes, that's going to shape the way that the jury views her once she gets on the stand. They may have their minds made up one way or the other right now. And if they have their mind made up one way and she says something that doesn't...
It'd be really interesting, and we can't do it, obviously. It's just not how court works. To see, it would be nice to see... we see the comments about what the jurors look like and how they're reacting. But it would be nice to have some really good insight into what they're thinking. It's unfortunate we just don't know. We were getting some information on social media that, they were looking a little bored during the cross. But this is tedious stuff. I mean, they're talking about stuff with all this software that a lot of people just probably don't know about.
Mm-hmm. Right. And, there are people that make entire careers out of reading juries, and some more successful than others. But at the end of the day, I think what I've realized is it's incredibly hard to look at a jury and predict what they're thinking based on body language. It's almost impossible. So if we could get a glimpse into what they're actually thinking, that'd be wonderful. If they could take a poll throughout the trial, that would be great stuff.
We're not supposed to know. We just want to know. So they were just nosy, that's all. We do have another question, and I'm told Karen Reed just walked back into the courthouse. So we should be resuming court. It's Karen's right as a defendant to be a part of sidebar. Right. I mean, people can do it. Remember when that whole dust up called Karen Reed up there for a sidebar one day? I kind of wonder if the judge is kind of making her come up there now. Is that a possibility?
It could be. I'm really not sure. I'm not sure what the motivation is to bring her up to all the sidebars. A lot of what's being talked about up there, as you know, is evidentiary issues and rulings as far as what attorneys are going to be able to ask or the words that they're using. So the necessity of having her at a sidebar, I think, is pretty limited. If the judge is ordering her to come up, I'd also wonder if part of that is because she doesn't want Karen turning around and talking to her family or making faces at people during sidebars. But again, I don't really know why she's up there. It's a very unique situation, though.
Yeah, it is. It is, of course, her right, but it's just not something we often see. But we know Karen Reed is very involved in her own defense. She's very, very engaged. So we know court will be starting back very soon. Stay with us here. We're going to take a couple more questions. Has the judge, this is from Kip Hubbard, has the judge been fair in her decisions? What's your thought on that? Austin? Do you believe Judge Cannoni has been fair?
I think she's been fair in general. I think some of the more troubling decisions for the defense have been what they've been limited to in terms of what they can talk about in opening statement. Those rulings really kind of handcuff them, because as a defense attorney, what you want to do is you want to get up and you want to create a narrative and tell a story. And if you can't mention ARCA or you can't mention these third-party culprits, that really kind of handcuffs you in terms of what you're able to say off the bat. So I think those have been tough rulings for the defense. Not that they were unfair, but they were just tough for the defense to swallow.
Sure. Our next question is from Diane H. Is Karen still facing a wrongful death lawsuit from the O'Keefe family, regardless of the outcome of this trial?
Yeah, and then that civil suit is still pending. The way that'll play out is if she's found guilty in the criminal trial, that can be used against her in the civil case. And the civil case has a much lower bar. It's a preponderance of the evidence as opposed to proof beyond a reasonable doubt. So if she's found guilty here, then the civil case is going to be a winner because of what happened in the criminal case. And even if she's found not guilty, all of this evidence can now be used in the civil case. You think back to O.J. Simpson and what happened there. Same kind of situation. There may also be a dram shop case involved here too. I mean, she's out there drinking at all these bars, presumably being overserved at them, and then she hits somebody with her car. So I'd be interested to see where that goes in the civil side.
That's really interesting. Stephanie Wayne has a question. What would happen if someone let the judge know that they had lied or been pressured to lie in the first trial? Hi from Australia. Thank you, Stephanie, for watching from Australia. We appreciate that.
That is a good question. So if one of the witnesses comes forward and says, hey, I lied outright in the first trial, then they're going to take the stand in the second trial. They're going to have to explain themselves, and they may be looking at a perjury charge. But beyond that, I'm not sure what implications that would have for this trial.
I want to get back to our poll results. We were asking who's more compelling, Hank Brennan or Alan Jackson. 1.5 thousand of you voted, and 87% said Alan Jackson. So that was the latest result of our latest poll. Thank you for voting, everybody. Our next question is from USA Kiwi 1986. Were the cops at the bar watching Karen drink as much as they say they are, saying she was, and then let her drive with John in the vehicle? Were they trying to set her up then?
That's an interesting question. It's another one of these theories that maybe the defense is kind of putting out there and letting people ruminate on and come up with their own theories around what happened and what motivations there could be around this whole conspiracy. But from what I've seen from the footage in those bars, it looked like everyone was drinking pretty heavily.
Yeah, everybody.
It wasn't necessarily a let's set this woman up. It seemed more like let's all get drunk and see where the night takes us.
Next question is from Jennifer Taylor. How come they did not test his scratches of dog saliva and find the rehomed dog and do some testing? Well, actually, they did. Maybe not on the scratches, but they did on the clothes. So Austin, they did test the sleeve and they found pig DNA. And then Chloe, the rehomed dog, the Albert's dog, they've tracked her down and they've taken molds of Chloe's teeth. So that's going to be presented as evidence from the Commonwealth this time around. The Commonwealth has been barred by Judge Cannoni from saying, or their expert has, I should say, from testifying that Chloe is excluded as the source of the marks on John's arm. But the expert can testify, I took these molds of Chloe's teeth, I took these measurements, and this is how far apart her teeth are and all of this stuff. So these things have happened.
Right. And the pig DNA was an interesting thing to have come up. But I think when you dig into that, that could have come from anywhere. I mean, it could have come from bacon. He could have been cooking something and gotten something on his sleeve. I think maybe the more interesting aspect of Mr. O'Keefe's clothing is what was found on Karen Reed's car. The pieces of clothing that is being alleged were found in the taillight, I believe. So that's an interesting aspect of it. But as far as Chloe, the rehoming and everything else, it's just another part of this case that something sketchy is going on and we just don't know what it is.
You are unmuted.
And when you put all these little sketchy things together from the defense, you end up with a pretty compelling whodunit situation.
Yeah.
I hope everybody enjoyed their lunch. My tacos were fabulous.
You are unmuted.
Jurors are entering.